Okay. Ms. Rivers, you ready? Let's go on the record in State versus Dill, 22 SC 181085. It's about 12:45 on the 14th. Mr. Dill is here in court with his lawyers. We've got our prosecutors, and we are going to talk, at least initially, about the draft jury charge. Before we dive into that, Ms. Willingham, good afternoon. Anything from the state that we need to cover? Okay, Ms. Feely?
No.
All right, let me get the charge up on my screen. So I got an email from you, Ms. Feely, that there are these other charges. When did you submit those?
I submitted the voluntary on Monday, filed it, and then the robbery not till yesterday.
Okay, and the timing doesn't matter so much, it's just I didn't catch them, and I was wondering how I missed them. So we need to talk about voluntary and robbery. All right. Let's start with self-defense. We haven't received all the evidence. We're going to hear from the lead detective. It sounds like the state's going to rest. You may call Mr. Dill's mom, and then we'll work through whether Mr. Dill testifies. Short of Mr. Dill testifying, what is the slight evidence that would justify giving justification?
We have kind of shifted our strategy at this point, and we are no longer asking for the self-defense.
Okay. Voluntary, on the other hand, I think that there is more than slight evidence to make an argument about the heat of passion or whatnot. Okay.
We would withdraw those.
Got it. Okay. Then why don't we go through the draft charge I sent out? When we get to murder, felony murder, that's where we can talk about voluntary. I'll need to massage the language a little bit because I didn't work on it last night. And I'll get the pattern. And then we can also talk about robbery. Let me do one thing here. All right, the patterns are working their way towards me. Let me. All right, so I've got on the screen the charge. I'm going to scroll to where I've got my first question. If I pass something about which either side has a question, say, hey, go back, please. And I'll go back. So my first question has to do with credibility of witnesses, and it's that final paragraph. Again, we're not done with all of the evidence in the case, but I couldn't think of a scenario that would support giving the charge of lining up witnesses' testimony to prior testimony or statement to the police or whatever. So I didn't know we needed to give that. It's not a question of is it valid law. I just don't know that this is a case where either side is going to be standing before the jury saying, well, you heard about person X's statement to the police, and then they testified to something differently now. Ms. Willingham, do you have any scenarios of that?
We don't.
Okay, and to be clear, it doesn't have to be statements to the police. It's a prior out-of-court statement. And you did reference the body cam, and that might be one. But if you're not planning on using the body cam, do you have any scenarios, Ms. Feely, where you'd like this language in because you'll be highlighting to the jury inconsistent statements?
No.
Great. I will take that out. Oof. I plan on giving defendants choice not to testify. I'll obviously tailor that if you end up choosing to testify, and we don't have to cross that bridge yet, Mr. Dill. But as a preview of one of the things I'm going to tell you, if you choose not to testify, I'll be telling the jury that you aren't obligated to testify. And if you choose not to testify, the jury may not consider that in any way in reaching whatever decision they reach. So currently, that's the charge I intend to give, but I'll take that out if you choose to testify. I'm assuming the good character of defendant was proposed by the defense. Take that out, or that's going to come in?
We'll withdraw that one as well.
Okay. And then all of the self-defense can come out. I won't strike it through right now. All the way through excessive force. So we get to murder. That's the pattern. Motive, felony murder. So I may need to put provocation by words alone back in. I'm going to strike through it. But I think voluntary manslaughter, if I give it, would go roundabout here, maybe just after murder or after felony murder. Ms. Willingham, do you have a perspective on whether I ought to charge the jury on voluntary manslaughter? Voluntary is not in.
No.
Oh.
No, if we were looking at something else.
Okay.
Your Honor, if you do it, we're looking for a jury instruction regarding a cooling off period. Oh, is that something we can revisit?
So, well, what I want to definitely cross the threshold now of yes to voluntary or no. My leaning is that I will give it. The standard is slight evidence. And I think the argument, I'm not making it for one side or the other, would be it was clear that Mr. Dill was upset. You can see it from the texts, and this is why you want cooling off. But that would be the voluntary. And then he sees the man who has stolen his woman, and he snaps, and he does what he does. That's a defense argument. I think there is slight evidence to support that. I think the defense ought to be able to argue that, and thus I ought to charge on voluntary. I think cooling off period comes naturally with that, given the facts of this case.
Yes, Judge, we don't have an objection to it being added. We just want to make sure that if it's added, that the cooling off period would also be.
Okay.
And we are looking for that. So
Okay, I will have Ms. Niles is looking for it too. Well, she's looking for the pattern. Why is that not there?
you're addressing with Stipulations, but could we go back to Malice murder?
In just a second, we can. I just want to close the loop. We'll need to all look at the language, Ms. Feely, but any reason why you would oppose the charge on the cooling off period?
I would want to see the language, but.
Okay, conceptually, you're not opposed to it. Okay, I think that makes sense. And so Ms. Niles just sent me the, oh, that's not helpful. I sent it to myself. Oh, so the pattern for voluntary, let me do this. I know you're never supposed to share your inbox on a screen, so don't look at anything other than what's right there. But if you look, it's kind of small, but I just highlighted the cooling off is built into the new pattern. We recently revised these. If you decide that enough time passed between the provocation and the killing for a reasonable person to have, and it's in quotation marks, cooled off and regained judgment, then the killing is not voluntary manslaughter. It's actually part of the pattern, and I think it ought to be given with it. I think it addresses the cooling off. I'll get it in a big font and get it to you again, but it looks like that's the voluntary charge that I'll give. And there goes my email. You don't get to see it anymore. Okay, so I'm just closing the loop on voluntary. I will give it. It has the cooling off period. I'm going to look at provocation by words alone. I don't know that we need to give it, given the facts of this case, but we can revisit that when you have the voluntary manslaughter language in front of you as well. Let's go back to malice murder. So Ms. Beza, and I want to be clear, when I call on one of you, I'm calling on lead counsel. If Ms. Wood wants to elbow in and say, I'm in charge, that's fine. So either one of you can address this stuff.
You don't have to page all address it.
Okay.
For malice murder, it's the state's position that rather it is the unlawful intent to kill without justification. That language, unlawful intent to kill without justification, should be deleted. Given the bench notes and the jury instructions, it says essentially give the parentheticals only if the exceptions are supported by evidence. For example, there's evidence that the defendant was engaged in self-defense and justification. Since we're not charging justification, it's the state's position that that wording should be deleted.
I guess I could remove, first of all, there are no parentheticals in, do you have the new pattern in front of you? Okay, well, does the pattern that you have for murder have the numbered elements, or is it just a paragraph full of text?
Numbered.
Oh, so you do have the new one. Okay. I'm not remembering that footnote. I helped write these, which is why I'm not remembering that footnote. I don't disagree with the concept. I'm not interested in telling the jury about things they don't need to worry about. I like them focused only on what they need. The word malice is, I worked hard to remove the word malice from the pattern charge, but my colleagues were wise and overruled me. One, it's in the statute, but malice makes people think like, I'm mad at you. I don't like you. And that's actually not what it means here. It simply means you intended to kill. I love you, but I'm gonna kill you. And I intended to do it. That's malice. But for people who use the word like, what? But you love the person. That's not malice. You're innocent. And that's not what it means. So we spent some time working on the language. It's not ill will or hatred. It's the unlawful intent to kill. I could go full stop there, put the period there, because we aren't talking about justification. But it is also the case that it's without justification. I don't mind removing those two words if that addresses your concern. I'm uncomfortable removing rather it is the unlawful intent to kill, because that's the contrast to ill will or hatred. That was the point of having the two sentences. Malice isn't what you think it is, where I hate you or I've got this thing against you. It just means the unlawful intent to kill. And so I can remove without and justification if those two words concern you.
Yes, Your Honor, as the defense withdrew justification.
Okay. Ms. Feely, do you have any concern about removing those two words?
Yes.
All right. I will do that. I think they're legally correct, but if you think it's going to distract the jury.
Because they may come back and say, can you define justification?
Right. What would be justified?
Yeah.
Fair enough. Okay. Anything else about the malice murder? Are there parentheticals in the pattern for malice murder?
I must have an old version because there are parentheticals and a bench note in this version. This is from July of 2021, unless there's one after.
No, there wouldn't be one after. What are the parentheticals in the murder?
It says rather it is the unlawful intent to kill, open parentheses, without justification, close, without excuse.
Okay,
without
fair enough.
justification.
We did that. I see. And I think what I do when I put it, I just keep without justification in there. But sometimes it's excuse, there are different affirmative defenses, excuse, justification, whatever it might be. Okay. That's a smart footnote then. Okay. Did you have anything else before we keep scrolling down?
Nothing.
No? Okay. That was all I had. So Ms. Feely, we'll talk about robbery in a minute. Did you have any other issues with the draft charge? Okay. Talk to me about robbery versus armed robbery.
So it's our position that while the first part had ended and while Mr. Dill appears to still have the gun in his hand, he doesn't point it. It's not involved in the, hey, give me that gun. He just picks the gun up off the ground and keeps it moving.
So it would be the pattern for robbery is taking another person's property from their presence by force or sudden snatching. And so I guess that it would be one of those as opposed to the armed robbery, because your argument would be Mr. Dill isn't using the firearm as the mechanism or means to create the threat or the intimidation or whatnot. He like, I'm gonna take your gun, and picked it up and walked away. Okay. All right. State thoughts about robbery.
It would be our position that he uses the firearm. I mean, he shoots the victim. So it would be our position that he does use the firearm. That's what creates the threat.
And that it's all one.
Yes.
You say, I want your stuff. The person says no, you shoot them. The person falls to the ground, and then you walk over and pick up their stuff. As an armed robbery. It's not a aggravated assault plus a robbery. It's an armed robbery. This case is different from that set of facts because I'm not aware of any evidence that this was about getting Mr. Stafford's gun, which of course was Ms. Willis Riley's gun. That wasn't what it was about. I mean, maybe you're gonna argue what you argue, but I didn't see anything in it. We have such little evidence about any interaction between Mr. Dill and Mr. Stafford. Obviously, it's a video, that's it. And then we know that they had a brief online interaction because he answered Ms. Willis Riley's phone once.
You're correct, Your Honor. That's correct.
Well, I don't know that it's correct so much as I'm going to give robbery. I think there's slight evidence to support that. I don't know that you could say that the original situation had ended, but I also don't think there's a whole lot of evidence that the intent of the interaction was to take anything from Mr. Stafford other than his life, which is an important thing, but that's not what the charge is. So I'll give robbery as well. Anything else from the defense?
No.
Okay, I'll need to clean up the overall charge. I will share it with both sides so you can see the final version and lodge any concerns if you've got them. Ms. Willingham, anything else about the charge?
No, Your Honor.
Okay, is your detective here and ready to go?
Your Honor, the state's going to call Mr. Dill's mother first.
Okay, and then the detective, and we've got the stipulation to work through as well.
Yes, Your Honor, I'm doing that part, and I did give the email to Ms. Feely last night and give her a copy today for everyone to sign.
Okay, and you can do that whenever you want. I just need to know, well, I don't even know anything. It just, when it's time, you guys are going to do your stipulation. Yeah, make sure we got all 14. They're rowdy in there. We got at least 10. Everyone's here? All right, were they harassing you? All day. If only you were a Nuggets fan. And let's talk about those Oakland A's. My gosh. Woo. I'm not ashamed to have that little magnet on my car anymore. They won multiple games in a row. They don't know what to do with themselves. Yeesh. All right, Ms. Willingham, I think the jurors are ready, so I'm gonna have them come in just a second. Your first witness is already here in court, and your detective is here. Also, is that the slick back here? Okay. Ms. Feely, you ready for the jury? Okay, let's bring the jurors in, please. Oh, what's on the screen? Oh, we're still sharing my stuff. Yeesh. Thanks.
What'd you say? Oh, you brought your own. Can't remember where I restocked.
All right, reserve. Judge the President.
Thank you, Deputy Gordon. Everyone else can be seated. Welcome back, my friends. Thank you for being on time and jovial, whatever you're doing back there. We are on day 2 of the presentation of evidence. I took care of drug court this morning, and we are transitioning back to state versus Dill. We remain in the state's presentation. So the state is presenting evidence through witness testimony and exhibits. And we'll keep going until Ms. Willingham says the state rests. Can you call your next witness, please?
The state calls Miss Matisha Mahone.
All right, Ms. Mahone, if you come this way, please.
46, they raise right hand. Right hand. You swear affirm that the testimony you'll give will be the truth, the whole truth, and nothing but truth, ever God. To go ahead and have a seat. State the civilian name for the record.
Matisha, Matisha, Mahone, Mahone, Jones, Jones.
Good morning, Ms. Mahone.
Good morning.
Do you know a person by the name of Carlos Dill?
Yes,
How do you know him?
he's my son.
And do you see him in the courtroom today?
Yes,
Can you tell me where he's at, identify where he's located, as well as a piece of clothing that he has on?
he's on my right. He's to your left with all black with the glasses on.
Okay. And do you know a person by the name of Tatiana Willis Riley?
Yes,
And how do you know her?
just by her dating my son Carlos.
Okay. Directing your attention to what's already been admitted as State's Exhibit 1. I want to direct you back to October 25th, 2021. Did you receive, I'm sorry, yeah, 2021. Did you receive a text message from Tatiana?
I don't recall the date exactly,
Okay.
but I may have received a text from her.
Do you recall receiving, I know you don't remember the date exactly, but do you remember receiving a text message with a screenshot of ring camera video?
I remember a picture. I don't know if it was a ring camera picture or not.
Okay.
Just remember a picture.
That's fair. Do you remember that text message also stating, "Come get your son"?
Yes,
And looking at the screen, is that the text message you received from Tatiana? And it might be in front of you as well.
Does that have a, if you press, what are the options on there?
unmute and stay muted.
Stay muted. Great. That, you should have a better view now. Thank you.
Okay, read what that message says for me.
Thank you for your gift yesterday.
And what's underneath that?
It shows a picture of someone fully dressed in all black.
Okay, and what does that message say underneath?
There is no message underneath.
In that blue box?
It just says the bedroom.
It's really large on her
Okay, now
screen.
it's showing. Now, this says, look at your son.
All right, thank you. And directing your attention to November 26th, 2021. Did you take the defendant to the hospital at any point?
Yes,
Plain States Exhibit 113. Do you recall what time it was?
I would say maybe about 12:30, 1 o'clock. Really not sure exactly of the time. I just know it was later. We had just gotten home from my mother's house from spending Thanksgiving.
pause it right there for me? And what do you see in that photo or in that video?
My vehicle,
Where's your vehicle?
the burgundy vehicle that is turning into the emergency.
We'll go to 113. And there's also, for this next video, there are some tools you can use, Judge.
So if you tap the screen one time with your finger and then look over in the lower,
Mhm.
is it, that's not it. There should be a circle. Try tapping again. Pardon me. Thanks. There, see that pencil over in the corner? Tap that all the way down. Great. Now your hand will be like a pencil.
Okay.
Okay.
Or a pen.
Can you pause it right there for me? What's going on in this video?
I just got out of my vehicle approaching the medical person here.
Okay, using your pen, can you circle that pen on the screen? Can you circle where you are?
And before you go further, I need Ms. Mahone-Jones to make sure when you're talking that you speak more into the microphone. So jurors all the way back can hear you. So if you need to slide forward a little bit, do that. That'd be great. And you can, the microphone adjusts. Unfortunately, it doesn't telescope out, but it does go up or down. Okay, thank you.
Thank you.
You can go ahead and erase that. There's an undo button.
Looks like an arrow that is in a circle over on the left.
Okay. And what's happening now?
Carlos is getting out of the vehicle and the paramedics is assisting him.
And I know that you communicated with Tatiana, we know that from the last exhibit. Did you communicate with her at all on this night?
No. I just received a text from her maybe like an hour or so later. I received a text from her maybe like an hour or so later of being at the hospital.
And back to State's Exhibit 1. Was that a fair and accurate representation of your text messages with Tatiana that day?
I don't recall those text messages. I'm not sure of what gift that she's pertaining to. I don't know of any holiday or nothing taking place or birthdays or anything taking place that a gift may have been given. So I'm not sure if that's even messages from me.
But do you recall receiving that message with the photo?
I do recall receiving the picture, but I cannot identify whom that is. It's nothing, not able to identify.
That's fine. Nothing further.
Ms. Feely, do you have any questions for Ms. Mahone-Jones?
Sorry. This one. Are you in possession of Mr. Dill's phone?
Yes,
Did you look at that phone?
yes.
Your objection, this is outside of the scope of it, right?
Right. So Ms. Feely is free to explore what she wants as long as it's relevant.
No. But the state also did receive this.
Okay, should we have a quick side? I don't know what this is. So,
We don't either, we asked for a sidebar.
okay. Why don't we take a quick break? You all stay put. Let's go back to our huddle spot. All right, Ms. Mahone Jones, sorry about that. We may come back to that exhibit. Ms. Feely has questions about a few other things. She's going to cover those, and then we'll explore defendants number one. Okay? Thanks.
Thank you.
That Carlos is your son?
Yes,
How many children do you have?
2.
Where does Carlos fall in that order?
He's the second child.
On November 26th of 2021, we saw a video that had you in it. Can you walk us through kind of what was happening? How did you end up interacting with Carlos?
I received a phone call from Carlos.
What did you do with that phone call?
Based on that phone call that I received, I went and hopped in my car, my husband and I, trying to find him in the area which he was trying to tell me he was at.
Find him?
Yes.
What did you do?
Once we found him, Well, once I found him, we quickly got him in the car and we rushed him to the hospital.
Saw there was something around his waist. Can you tell us about that?
Yes, that was the shirt that I had on. I actually had on a shirt with a jacket, and seeing him with the gunshot wound, I hopped in the back seat with him, and I tied my shirt along his waistline where the gunshot was at.
So you tried to provide some,
Suppression to his gunshot, yes.
when you arrived at the hospital and Carlos gets medical assistance in the emergency room, right?
Yes,
And he subsequently had surgery that day.
yes, overnight, until early morning.
And after the surgery, he stayed in the hospital for a week.
Yes, it was about 5 to 7 days. I can't remember if it was longer than that, but I do remember it was like 5 to 7 days that he was in the hospital.
Personal report stated that states exhibit 23. The Carlos hospital,
Yes,
and you've got something, using medical equipment, helping him breathe, right?
yes.
Was this before or after the surgery?
I would take it that this is after the surgery. We were not allowed to see him afterwards.
Did you take that picture?
No.
Going back to Defendant's Exhibit 1, got some questions for you.
Okay.
Your mistake with discovery, we have not had an opportunity to do this, we haven't had an opportunity to speak with any witnesses regarding this, so we will check this out.
Okay, well, we talked about that when we had our sidebar, and I will exclude defense one. I'll give you, Ms. Feely, an opportunity to make a fuller record about defense one when the jury's not in the courtroom. Okay, all right. Did you have any redirect of Ms. Mahone-Jones?
Nothing wrong.
All right, ma'am, thank you for your testimony.
Thank you.
Next witness.
Detective Charles Sendling.
So affirm that testimony will be able to be true, the whole truth, and nothing but the truth of God.
I do.
Go ahead, I'll see. Stay swear man for the record.
Detective Charles Sendling, Sendling.
Good afternoon. Good afternoon. How are you currently employed?
City of Atlanta,
Is that with,
the police department.
and how long have you been there?
August will be 21 years.
And where were you previously employed?
United States Marine Corps.
Were you employed with APD on November 26, 2021?
I was.
And what were your responsibilities and duties?
I was assigned to the homicide unit.
As a homicide, assigned to the homicide unit, what was your role?
We conduct death investigations, murders, suicides, sometimes naturals.
What was your title back in 2021?
Detective.
And were you post-certified at that time?
I was.
Can you tell the jury what post-certified means?
Means you've met the state mandated requirements to be a police officer. I believe the state mandates like 11 weeks. Atlanta is twice that.
Are you still post-certified?
I am.
Back on November 26, 2021, did you become involved in a case involving Colonel Dill?
I did.
Courtroom today?
Yes, he's at the defense table in the center with a black shirt and glasses.
And Your Honor, let the record reflect that Detective Sendling has identified Carlos Dill.
He has?
And how did you become involved in that case?
I was number one in the rotation at the time that this incident had occurred. I was called at home and responded back to the city to lead the investigation.
And did you respond to 3440 Boulder Park Drive, Southwest Atlanta?
I did.
Is that in Fulton County?
It is.
What was the nature of that call?
I had received information that there was a shooting at that location and the victim was deceased.
Do you recall what time that was?
I don't remember what time I got the call. I know the call came up around 12:35. I don't remember exactly what time I was called.
Was the scene still being processed at that time?
It was.
And when you got on scene, what was out there?
Some shell casings, a magazine, a witness, and a neighbor who had video.
Okay, and what was that witness's name?
Tatiana Willis Riley.
And did you get the neighbor's information?
I did.
What is that neighbor's information?
She chose to remain anonymous.
And did you obtain the footage from that neighbor?
I did.
You mentioned there were some shell casings on scene. Did you also locate a firearm at all?
There was no firearms on scene.
Were there ballistics done?
No, no.
Why would we have done that?
We would have done that if there was weapons to compare the ballistics to, but there were no weapons on scene.
And you say that you also collected video footage. Do you recall what that video footage was of?
From the neighbor? Yes. It showed Mr. Dill out there within the video. There's several videos. The video I got that night basically showed the shooting itself.
I'm sorry, let me stop you there. Did you have an opportunity to review those videos for today?
Yes.
States Exhibit 22 and States Exhibit 114 A and B.
Yes.
And back to the neighbor's video, which would have been States Exhibit 22, that's been previously admitted. After you viewed that video, what did you learn?
I learned that through the video and having conversations with Miss Riley, that Jonathan Stafford, the decedent, had parked her car in the next parking lot over in an effort to hide the fact that she was home. So I learned that when he parked the car, he did not have the keys. So she had to come over and meet him so he could turn the vehicle off. You could see them walking down the sidewalk, and you can see Mr. Dill creeping through the parking lot, and then comes up onto the sidewalk, runs up behind him and puts a gun to the back of his head and shoves him.
And did you do any gunshot residue?
No.
when did you apprehend Mr. Dill?
Mr. Dill was apprehended much later that morning. He had showed up to the hospital with a gunshot wound from this incident. That was learned, and after we concluded our investigations, warrants were taken out and he was arrested at that time.
And why didn't you do the gunshot residue test?
Well, we didn't do it on the decedent because he'd been out in the rain for a while and he wasn't on the scene. He was already pronounced deceased at the hospital, and Mr. Dill was supposed to be going to surgery.
You mentioned the neighbor's footage that you collected. Did you also collect any other footage?
I did a few days later.
What other footage was all collected in this case?
It was also video in front of her apartment that showed him, Mr. Dill, being present in the complex where he does not live for about 4 hours prior to the incident.
Ms. Feely, do you have questions for Detective Sendling?
Do you often let witnesses and referees remain anonymous?
We do. She wasn't really a witness per se. She had video footage. She didn't actually see the incident. She saw it on her video camera.
And you said you did not do ballistics because there was not firearms at the scene.
There were no weapons on the scene.
But your testimony, the only way to do ballistics is if you find a firearm on the scene.
You have to be able to compare the shell casings to a firearm.
Right, so throughout your investigation, you could have come across a firearm.
We could have, but we didn't locate a firearm. Nor did we know where Mr. Dill went after the incident.
You didn't search any vehicles that he might have been in.
We didn't locate any vehicles.
But you didn't do ballistics because.
There was no weapons to compare it to.
So it's important that you guys not talk over each other. You may know where the question is going, but there's no early buzz in. So please let Ms. Feely finish the question, then you answer. That way the court reporter's not trying to type two voices at once.
You said you didn't ask for gunshot residue because the rain, is that right?
On the decedent, yeah, he was already off scene. Plus, there was video of the incident as well.
Have scientific training to believe that rain would wash away all gunshot residue?
No,
It's possible there would have been some.
it's possible.
Ms. Willingham, any redirect for Detective Sendling?
Nothing.
Any questions from the jurors? Sure, take your time. Thank you. So Detective, there is some video footage that's been admitted that might show that Mr. Dill left the apartment complex after this incident in a white car. Was that a vehicle that your team was ever able to locate?
We weren't.
Any other cars that the video evidence may have associated Mr. Dill with recovered and searched?
No. We later learned that there was another car out there, but by the time we learned that, I went back out there, it was gone.
Okay. And from the video footage you watched, was there anything that would allow a non-stranger, someone who didn't know Mr. Dill or Ms. Willis Riley, to identify who the people were captured in the video that showed the shooting?
So what you're asking, sir, is if she wasn't able to identify him, would we be able to identify him?
Correct.
Okay. So I don't know if y'all noticed, but in the video, there's some very distinctive shoes, especially the video from 4 hours earlier. And if you look at the shoes from the video at the complex versus the video at Grady, the shoes are exactly the same. They're white, black, and gray.
All right.
Then he shows up at the hospital with a gunshot.
Ms. Willingham, do you have any follow-up questions for the detective based on these questions? Ms. Feely?
So you said you did not find the card. It looks like, right?
We didn't have anything to go on. I mean, white Nissans or a dime a dozen, we didn't have a tag to go on.
They're tag readers, like on every block, right?
Yeah, no, not on every block. There's actually fewer than you actually would think there are, but
Don't give away any secrets here.
Okay, so you did not.
we did not locate the car. We did try, but we didn't locate it.
All right. Thank you, detective, for your time.
Thank you.
Ms. Willingham, next witness. Okay.
All right, at this time, the state moves States Exhibit 163 and 164, which is two certified convictions. Pursuant to OCGA 249902 and self-authenticating documents, it was shown to the defense previously. State moves these into evidence.
Okay. Can you give me the indictment number for each, just so I'm linking 163 to the right one?
163 is going to be the 14 SC 128673.
All right.
And 164 is going to be the 15 SC 139324.
And those are certified copies of indictment, plea, and sentence?
Yes.
Got it. Any objection, Ms. Feely, to the admission of states 163 and 164?
No.
Got it. Okay. And?
In addition, Your Honor, the state moves States Exhibit 165 into evidence at this time as a stipulation by the parties.
Okay, before you read that stipulation, ladies and gentlemen, let me remind you of a legal instruction that I gave before. I want to find the right language here. You are about to receive evidence of prior convictions of Mr. Dill. You may consider this evidence proof that he has convictions. Juror number 2, you okay? Okay, great. That only insofar as the evidence you're about to hear may relate to the required element of having been convicted of a felony. You'll very soon are going to hear from me about counts 10 and 11. Those were the possession of a firearm by a convicted felon. And it's an element of that crime that you are a convicted felon when you have a gun. It's a crime in Georgia to possess a gun if you're a convicted felon. And this information you're going to receive, you can consider only insofar as it proves to you that Mr. Dill was a convicted felon at the time he may have possessed a gun in this case, and for no other reason. Ms. Beza.
We'll stick to the 165.
Okay, and that's the stipulation.
Yes, Your Honor. The stipulation reads, both parties stipulate to the following facts. Carlos Dill Jr. was convicted of a felony on August 8th, 2017, in indictment number 15 SC 139324 in the Superior Court of Fulton County and is still considered a convicted felon. Exhibit 164 is a true and accurate copy of the defendant's certified conviction for case number 15 SC 139324. The second paragraph reads, Carlos Dill Jr. was convicted of a qualifying felony on August 8th, 2017, in indictment number 14 SC 128673 in the Superior Court of Fulton County, and is still considered a convicted felon. Exhibit 163 is a true and accurate copy of the defendant's certified conviction for case number 14 SC 128673. Signed this June 14th of 2023. It purports the signature of Carlos Dill Jr., the defendant, Lee Philly, his attorney, and Jacqueline Willingham, assistant district attorney.
Thank you. Ms. Willingham, next witness.
This time, state the rest.
Okay, ladies and gentlemen, the state has concluded its presentation of evidence in its effort to meet its burden of proof. We're going to take a break now because, as I told you yesterday when I was giving my preliminary instruction, when the state rests, there's some legal things we need to work through outside your presence. So we're going to do that now. This will be your first break this afternoon. We'll see if there's a second one. Please go with Deputy Gordon. Don't talk about the case yet. The fact that the state has rested doesn't mean that the evidence is closed. What's going to happen next when you come out here is that I'll ask Ms. Feely to call her first witness. And she may say, we call witness so-and-so. She may say the defense rests. No burden on the defendant, but they have a right to present evidence and they may choose to do that. So talk about anything else but this case. No outside research. We'll get you back out here as soon as we can. Thank you.
All right, it's yours.
All right, Ms. Feely, two things from you at a minimum, and then Mr. Dill, we need to have our conversation that I forecast yesterday about whether you want to testify. What I'd like you to do first, Ms. Feely, is get on the record what you would like to in connection with Defendant's Exhibit 1. I'll give the state an opportunity to perfect the record from their side in terms of timeliness of disclosure. Then, when we're done with that, if you've got any motions, I want to hear those now that the state has rested.
So I first point out for the record that a whole entire body cam that disclosed in this particular trial, this kind of stuff happens all the time, asking the court to exclude defense's one and only exhibit based only on late disclosure when it's a phone that they should have done and obviously entered many messages throughout the course of this trial. We think maybe I need to reframe my leniency when these things happen, maybe not for the whole office, but it's not harmless because this shows that Tatiana tried to call Carlos. This whole case is based on Tatiana's credibility, and this was going to be to challenge that. She said she had blocked him. She said she didn't want to have contact with him, and we have direct evidence to the contrary, impeachment evidence to the contrary. So the fact that I was not able to get this in because the state somehow did not have access to it, and their only objection is that it was not disclosed to them, even though all the other messages we have, and I can't verify if they don't have it, but they're saying that they don't, and their officers in court, so it's my position that it was ineffective of me to not make sure that they got every single message from this phone that is their star witness's phone. And since I did not do that, I am fine with just making sure to preserve the inevitable ineffective claim, and it is very much not harmless in this particular case.
So a couple of questions for you. And then, like I said, I'm going to give the state a chance to maybe further flesh out what defense exhibit number 1 is. Defense exhibit number 1 is a screenshot taken not from Ms. Willis Riley's phone, but your client's phone. Is that correct?
That's correct.
Do you have any evidence that the state ever possessed Mr. Dill's phone?
No.
Okay. And it's a screenshot not of the Instagram stream of which we saw, or from which we saw many, many screenshots, but it is a screenshot from Mr. Dill's telephone app showing that he received a phone call from a number that you contend, and I'm not disagreeing with you, I just don't know, that he missed a phone call, not an Instagram message, but a phone call from the phone you believe to be Miss Willis Riley's phone.
Right, and for the record, that number is 470-318-7910. This is November 26th of 2021 at 12:30 a.m. A missed call from her number, and I would point out that she testified that she had blocked him. So that's further inconsistency that we would be able to argue.
Well, blocking means that if I try to call you, you don't see the call coming from me. I don't think it means you couldn't call me. It would be peculiar for you to call me if you blocked me, but I'm not making any IT findings on this either. I just want to make sure I understand what defense exhibit 1 is. It comes from your client's phone, which the state never had, and it is not Instagram. It's actually from the phone app showing a missed call from, and the state's going to need to agree or disagree, Ms. Willis Riley's phone.
Right.
Okay.
In theory, that would show an outgoing call on her end.
Sure. Okay. And you didn't ask Ms. Willis Riley about this call she purportedly made. Is that also correct?
That was an oversight on my part. I hadn't get it in through her.
Okay.
But then again, I didn't realize that they didn't have it. So this would have been just an issue with her.
Right. But had you asked her, I'm focused more on your observation that, wow, this shouldn't be excluded. Had you asked her, one, you didn't need to use that unless you were going to impeach her. And if you were impeaching her with it, it wasn't something you needed to disclose in advance.
Yes.
Okay. All right. Got it.
Would have been used for impeachment.
Got it. Okay. Ms. Willingham or Ms. Beza, anything you want to get in the record about defense exhibit number 1?
Your Honor, had we had this prior to now, we would have had an opportunity to ask Ms. Riley about it. Even if it were used for impeachment purposes, again, we would have had an opportunity to at least ask Ms. Riley about it while she was on the stand. Had it been provided to us earlier, it is something that we also could have looked into. We could have spoken with her about it. As Your Honor has already noted, it is not a photo from the screenshot. It's a screenshot photo from the defendant's home, which we never had in our possession. So we would not have had access to it. And for those reasons, we believe that it's proper to be excluded at this time.
So I want to be clear. I'm not necessarily excluding it because you couldn't have had access to it. It may well be that through working with Ms. Willis Riley, you would have learned from looking at her phone. But what you've explained to me is that those screenshots of texts, Instagram exchanges, you didn't get from her phone by having her phone. You got them from law enforcement because somehow law enforcement got them from Ms. Willis Riley.
That is correct, Your Honor. Those photos that have been admitted were photos that Ms. Riley screenshotted herself and sent to law enforcement. They are not photos that we were able to pull off of her device. We never had access. We never had direct access to it.
To her phone
Her-
or Mr. Dill's phone?
Correct.
Okay, all right. Couple things. I'm going to continue to rule that defense one should be excluded. I don't think the number of exhibits is material. I appreciate that's your only exhibit. You could have had 99 other properly disclosed exhibits. This one would still be an issue. The body cam video comparison, I also don't know is apt. It was definitely late disclosed. Had I let the state use the body cam video footage over your objection, then I think you ought to be frustrated with me for saying, oh, but it's different for this. Although it sounds like you've had this all along and just assumed, Ms. Feely, that the state had it, whereas the body cam video footage, the state, as defined by DA's office, they didn't have. I appreciate that the law is really the state has had the body cam footage the whole time. It was late disclosed. The state ended up not using it, but I gave you the opportunity to use it if you wanted to. It was late disclosed, no question about that. So I will continue to stand by my ruling that defense one is excluded. You've made your ruling, your observation that maybe it's a bad ruling, and if it's regardless of the wisdom of the ruling, it is going to be subject to an ineffective assistance claim. The state was put on notice that you would make that point, and the state persisted in objecting to the admission of defense one. I think that is as much as we need in the record there. Do you have any motions now that the state has rested?
Yes, we would move for a direct vote on the armed robbery count eight. Just checking to see if there's a felony murder associated with that.
I think there is. Yes, count three. So there's felony murder on ag assault, armed robbery, and then the two convicted felon gun charges.
So we're moving to reject the verdict on counts 3 and 8, based on the evidence that has been presented. This does not meet the armed robbery elements.
So I've got those elements in front of me. What are we missing?
By use of a firearm. The firearm was not used in taking. He just picked it up off the ground and never pointed the firearm at him, never asked the gun.
Of course, he had pointed the fire at him for a while because he got 6 bullets into him. But you're saying they were 2 separate incidents.
As the court's already pointed out, there's nothing about this encounter that was about taking anything from Mr. Stafford.
Okay, so it's almost an incident to the serious incident.
Right, and there's no intent there.
Okay.
There was armed robbery.
Okay. Someone from the state respond. I think the felony murder, that just flows naturally. You don't have to talk about the felony murder. If there's no armed robbery, there's no felony murder predicated on armed robbery. I'd like you to answer that question of intent. Clearly, Mr. Dill took someone else's property, element 1, and it was from the immediate presence of Mr. Stafford, element 2. By using an offensive weapon, I mean, at that moment, no, but Mr. Stafford wouldn't have been prone had an offensive weapon not been used on him repeatedly. It's more, and I don't think Mr. Dill picked it up to keep it safe for Mr. Stafford, but it's the larger intent. Was there an intent to use the firearm in an effort to get the gun?
Under Robbery state,
Ooh, can you spell that?
BERGARA, and I may be pronouncing it wrong. 287 Georgia 194 is a 2010 case. It finds that you are authorized to find that if a theft was completed after force was employed against a person, a conviction for armed robbery is authorized regardless of when the intent to take the person's property arose, whether the victim was incapacitated, and even if the victim was killed instantly.
Okay.
So And Your Honor, we would also be asking for these to be added as charges. And we're gonna email that to you.
Okay. All right. So Mr. Dill, the motion that your lawyer made was properly made. This is the time to do it. It's a tough motion to win. The standard for a motion for a directed verdict is whether or not there is any evidence upon which a guilty verdict could be supported. And I find that there is some evidence that the jury could believe that I think there's plenty of evidence that you shot Mr. Stafford. And as a result of that use of force, using an offensive weapon against Mr. Stafford, you were able to take the gun. I think your lawyer has a good argument that that was never the overall intent. But the state's going to be arguing it may not have been going in, but as a result of the use of force that incapacitated Mr. Stafford, you were able to take the gun from him. And it doesn't matter legally that it wasn't his gun, it was someone else's. It was the property that you took from his presence. So I'm going to deny the motion. I think it's one that's complicated for the state to argue that count, but I can't say that there is no evidence. I think the evidence that you intended to take the gun is there in the video. You took the gun. You didn't trip and it ended up in your pocket. You bent over, you picked the gun up and you walked away. So you clearly intentionally took the gun. It's going to be for the jury to decide whether they are convinced beyond a reasonable doubt, pretty high standard, whether it's appropriate to build the bridge between whatever intent they find that you had in shooting Mr. Stafford with taking the gun. But I will leave the charge in place because I do think there is some evidence upon which the jury could rely. Anything else, Ms. Feely?
No, Your Honor.
Okay, Mr. Dill, do you understand that you have a right to testify and that if you want to testify, no one can prevent you from doing so?
Yes.
Do you understand that in the same way, no one can compel or force you to testify? In other words, you have an absolute right to remain silent during this trial.
Yes.
Do you understand that it is you and not Ms. Feely or Ms. Wood who must decide in the end whether you will be testifying?
Yes.
Do you understand that if you choose not to testify, I will instruct the jury that they are to draw no conclusions or inferences or anything at all about the fact that you did not testify?
Yes.
In fact, I think I showed you the language on the screen. That's what I will be telling the jury if you choose not to testify. Do you understand that if you choose to testify, not only will you answer the questions from your lawyer, but you will be subject to cross-examination? Ms. Willingham or Ms. Beza will get a chance to ask you questions, and you don't get to say, well, I'm not answering those. I'm only answering my lawyer's questions. You understand?
Yes.
So you'll be subject to cross-examination. Understanding those things, Mr. Dill, do you want to testify in your case?
No, sir.
Okay. I find that Mr. Dill has made his decision not to testify with a complete understanding of his rights and the consequences of his decision, and you will not be testifying. Ms. Feely, do you plan on calling any other witnesses or tendering any other evidence? So we'll bring the jurors in, and I will ask you to call your first witness. You will rest. And I guess we have to send the jurors back out because I need to finish the jury charge. I need to get whatever non-pattern charges the state is sending my way. And we need to work through that. Is there something else, Ms. Feely?
No, I was just gonna say, I just got them as well, so I'm sending these to my appellate division, but,
Everyone will chew on them. But let's bring the jury back in a moment. They'll then know that both sides have rested. We'll need to finalize the charge. There is time for some closings this afternoon. How long do you envision your closing being, Ms. Willingham?
Probably total, Your Honor, about an hour and 15.
Okay, and do you plan on opening and closing? All right. Ms. Feely, any sense on your part?
probably 45 minutes to an hour.
Okay. We'll certainly have time for closings. We ought to do that today. It may be then we end rather than I charge the jury and they deliberate for 5 minutes. But let's see how long the closings take. Why don't we bring the jury in and then we'll take a break while I work on the jury charge. and we can reconvene. Thank you. Everyone can be seated. Ladies and gentlemen, we are now going to turn to the defense to see if they'll be presenting any evidence. I know I'm going to sound like a broken record, but it merits repeating. There is no burden on the defense. So Ms. Feely may choose to call no witnesses, and then we'll keep pressing forward. Ms. Feely, if you'd call your first witness, please.
At this time, the defense rests.
All right. Ladies and gentlemen, the evidence is closed. You have received all the evidence that you're going to get through witness testimony, exhibits, plus that stipulation. Two things now separate you from now and deliberations. First is the closing arguments or summations from both sides, and then the charge that I have to give you. I need to talk with the lawyers a little bit longer about the jury charge. Because of a couple things that have developed during the course of the trial. I need to make sure the law I give you fits the way the evidence has unfolded. So you just had a break. You're going to get another break. When you come back in, you will hear the first part of the state's closing. Because the state has the burden of proof, they get to open and close with closing. So Ms. Willingham or Ms. Beza will get up and give part one of the closing. Then if Ms. Feely wants to give a presentation, and I bet she will, but she doesn't have to, she'll give her closing argument, but then the state gets the last word, sort of a rebuttal to whatever you might hear from Ms. Feely. When those closings are done, we'll see what time it is. If it's early enough, I may give you the jury charge. Otherwise, it may be you leave a little early today, come back tomorrow morning, I give you the charge, and you start your deliberations. I don't think we can fit in closings and charge and give you a meaningful amount of time to deliberate. It doesn't make any sense to send you back to the jury room at 5:15 because you can't stay here all that long. If it were Friday night, we'd let you stay so you don't have to come back on Tuesday because we're closed for Juneteenth. But it's only Wednesday. So if we get through closings and it's getting close to quitting time, you won't stay awake for the charge I give you anyway. So we'll do that in the morning. Any logistical questions? This break will, yes, sir.
It's not logistical, but we were given an option to ask questions.
On one witness, and that was my oversight. You should draw no conclusions from that. I forgot. It's my role to two things. Most judges don't do this. Most jurors don't get to ask questions. If you're a juror, again, don't be looking sideways at the judge saying, well, wait, now's the time when we write questions down. There are only two of us on Superior Court who do that. I think it's real important. You get to do it. I blew it. And when that witness was done, it had nothing to do with her testimony or the questions of the lawyers. I just forgot. I was processing the issue about the exhibit and whatnot. So that is correct. You didn't, my mistake. But otherwise, it should have been all the witnesses. Okay. During this break, just because evidence is closed doesn't mean you should start deliberating. You really don't know what to talk about yet because you don't have the elements of the crime. So I will get those to you when I give you the charge. Feel free to spread out down the hallway if you want, as long as you do it in a quiet fashion, and we'll get you back in here as soon as we can. Sorry for the back and forth, but trials wrap up this way. And so there's an extra break for you all. We'll see you soon.
All rise for the jury.
All right, I'm going to go back and work on the jury charge. We'll come back out and finalize that. You all can be thinking about your closings. Mr. Dill, I'm going to have you go back there until I come back with the jury charge. You'll obviously be out here anytime we're talking substantively about your case. But it's just easier to manage the situation if you're there while we're taking a break, okay? All right, before we go off the record, Ms. Willingham, anything else from the state?
Nothing further.
Ms. Feely for the defense.
No.
All right, thank you. I'm going to give you Court's Exhibit 1, smallest one ever. Yep.
Okay.
Do you say like 15 minutes? Or maybe? Okay. Thank you, Ms. Rivers.
They did. I went out here. Yeah, actually started this shit. I know.
Oh, there's.
I mean, yeah, I just here. I had to wait 4 years. I really long with that. I always said I don't know. I didn't do it so long. They try to hold me out. Or whatever you want. What you trying to do? What you trying to do? I couldn't do more. But they're trying to hold me. I'm right now, I don't do like that. Oh, you're trying to be sorry? Yeah. Oh, you got to hold my train. I ain't shit Caroline. I ain't still buckle. Like right now, I still buckle. They have those. I was not going to do it. I ain't call for the real. I said it. I was saying, it was check it out. I'll check that out. No.
7:30 at night.
7:30 in the morning. Our host told try to make Tennessee. I might not have game might go for a team, but I might not get back to my like 12. Yeah, they don't even what's man. Say the power. What do you want to say? No, it's dead. All right. That ride with me all back. I'm like, I ain't gonna do that. I got kids to do that.
Well, I put it.
And we would be on, walking with you on, animal,
No, that was.
It was a death. I came back like 2014, they moved out to jail first. GMA. Sorry. But you can't get me, this was committee outreach. Just 10. August over against all the year. But school, you know. Yeah, once you get your admin, how you want it. Kids, easy. Like the kids, is like, they like a job on themselves. Yeah. Yeah, go do kids stuff. The stuff they don't do how I was doing in school, I get it. But I don't understand why class is so long. Class is 90 minutes long. That's a lot of time to be in a classroom for teachers you don't like.
Okay, it's not like 7:30.
High school, middle school. This is pretty private, I mean, pretty public school. The same field, you know, so something that, what is it, like, about a million, you know, why am I saying, yeah. Hey, my God, you know, the supervisor, no, him and no man.
Oh, he was supervisor now?
Yes, sir.
Yeah, I thought he was still, I thought he was, that's good. He don't make a song.
Yes, sir. They try to do it for the so. He's doing a work out.
Oh. Shit, that means-
Nice hanging out with my wife, but- I had to right there. It's really a temper. I feel something like I have to do something. I wanted to, I actually want, you already know, no, you want me to lose. You know I will. Actually, a little tough, I said, look. Instead of starting with 5, then on that side, 10 more, she said, what? 10. Well, I can folks you too. What's a jury?
It's a non-skill.
Okay. Don't worry about it. Don't worry about it. I'm not gonna come over there. I'll pass them and pick it up on the 3rd floor. Okay.
You going out with it? I agree. I do know what the report.
No, you said you got that. I'm trying to tell you. I'm trying to tell you, I'm like, my thing is, I'm like, listen, I ain't never worried. I get you.
Y'all in jail circle, though.
Nah, never would, bro. Oh, you know, that's worse than you. But she's a car.
That was security, not jail circle. That one was security, not jail circle.
Cause I don't even know how to.
person like, I've been to the gym twice. Orientation, then we had that Malice county out like this.
That match was my first time going in there, because I'm used to dropping them off. I don't know what they do.
I'm telling you.
It was like it, but at least when I hoop them and everything. Yeah, but yeah, work out with them too. Yeah, water bag. Yeah. I don't know. I don't know you trying to remember your name. I don't know those. I don't know
Teamwork makes dream.
And then, what did he say yesterday? He was like, you know, what's Connor for important to the business? And I was just like, yeah, you're on I mean, it's like,
We would have taken this way down. One of them down there. Well, not saying this.
Made it back in time. Goodness.
We're not.
I don't know. You know. You know, saying, baby,
I'm gonna tell you something. So you can talk about it too. We perfect. If you have it. What's the time? You have to do a whole photo. That's somebody trying to say, see it again, waiting, she saw it, it wasn't her, dude probably had it. He was probably like that. I don't know what happened. Like, they were here, like, all our stuff on the floor. He was making some assistant, down the program, he was talking to my assistant for every quarter. It was like, oh, it's not even like that, kind of, you be hollering.
Oh my God. Something went flying. I don't know where it went.
Whatever it is. I see it happen.
in front of you.
Right, now you got it, it's a, you might try to buck it for you to get to it. Now you got to call it all real quick. You might go to this, don't go to this one. But I'm gonna cut you off.
You gotta check, you know, you gotta check. But they ain't gonna go to the elevator, they gonna step.
They know they going.
Yes, yeah.
You gonna go, you can't go, what? I'm saying, you're gonna go back down there, not going to the elevator. Like that's.
Now you told me like 4 times, I ain't seen you. I don't know, I'm there, I've been in there.
Oh, no,
Don't do that.
not now. Don't do it. But I'm everywhere else. I'll see.
All right.
But also too, I was gonna say, too, so you know. I was thinking, send a letter in for warning, it's gonna come like I.
Yeah, it might be something might come in, right? Like, come for a good, she might say it's good.
But that's.
You ain't got no extra car nowhere. You got one.
Now you.
Now you got a red car on the radio. He looking at it, you know he got one. Shoot that car in. You trying to do it with everybody? No, right with it.
Yes, I was like, you little girl, she tried to leave, I saw her.
Oh, that's what that was? Can you like, send it?
Or is it not bad?
Oh.
Right. So, you better do it. Okay, right, that money. Oh, I really should, I see that. No, sir, I ain't staying here all night. No. This little bitch stand right here back, 8:30. Yeah. Yeah, no, ATM song. Friday, I got that money. When that Friday, no sir. And like I did something, you know.
Is it working now?
Yes.
Yeah, it's working now.
Wait, oh, okay, yeah.
It's a, I'm gonna ask you.
Okay.
You got homes first? Yeah. Who's this?
What year?
I graduated in 2017.
Oh, yeah.
I see you before I was like, you look really on the right on.
Yeah.
Straight over?
Sure.
I see my face. You don't do all.
You call.
When you said the
I just sit on behind it.
I'm thinking I'm finna, you know, reach out or you got somebody knows. Hey, but I know you. I don't know you. It ain't me, man. I look like somebody.
I see it, dude. He in school, they just staring at you. When they see you already calling, why you looking at me, man? I know you for it. I was working in school. I don't know what school. I get over there, calling. You get them all, it's anything in your face the whole time. What's up?
Yeah, one guy. Oh, on the screen.
So,
All this stuff. That's the worst.
you don't know the virus, you like, no. Okay.
I was at Apple. This is my key. Good job. It was that person, look, that person was sick. No. Oh, my son, look, that's my son,
Did you test out everything?
Yes.
Okay.
You actually tell people? Yeah, back with that, he just Malice, like he had to play. Oh, yeah. My circle, but it ain't even that, it's just the person, it's just that insurance home, so. It's because it's gonna put it out there. You know what I'm saying? Like, you just don't even know. My circle's so small, man, I don't
Added value every time you've done this, one for each side.
Yes.
Thanks. Can we get Mr. Dill out here, please? All right. Ms. Rivers, you ready?
Yes.
We are back on the record in State versus Dill. I have up on the screen the revised jury charge. There is a hard copy available, one for the state, one for the defense. I'll tell you the changes I made, other than things we already agreed to. On page 5, I added, oh, come on, scroll. This paragraph about identification. It is the short form charge on identification. No one requested it. I don't want there to be an issue in the future that I didn't give it. The state has to prove identity. And this just simply says that it's the state's burden and the defendant doesn't need to prove someone else did it. Any objection to that being in there, Ms. Willingham?
No objection.
Ms. Feely?
No, no.
All right. Voluntary manslaughter is in bottom of page 7 and top of page 8. That cooling off language is there. That's straight from the pattern. It's not a special add in. I did remove provocation by words alone. This doesn't seem like the right case for it. It's not what was going on. We don't have any evidence that Mr. Stafford said anything at the scene there. He may have said something on the Instagram. We don't know what that is, but I just don't think it fits. And it leads the jury in a mistaken direction. Any objection to provocation by words alone not being in there, Ms. Willingham?
No objection.
Ms. Feely?
No.
Okay. Then when we get to armed robbery, you will see I added a paragraph. It is in at the top third of page 10, and it comes from Vergara, Vergara, the case that Ms. Willingham shared. Those are both correct statements of the law, And that case in particular affirmed a jury instruction to this effect. So I need to see if that language works for the state. And then Ms. Feely, if you have any concerns, you can get those on the record. You see the two sentences I'm talking about? Yeah, take your time to read them. I just want to make sure you've looked at them. Does that address the concern you had, Ms. Willingham? Okay. Ms. Feely, have you had a chance to read those two sentences?
Yes.
Okay. Any issues with those?
So we're talking about just right above robbery.
Correct. The armed robbery charge, the only thing changed from it, I think, is that there were parentheticals. I took the parentheticals out. I added that paragraph just above the word robbery.
So there is language that in that same case that during a discrete incident, because I want to make sure that it is, you can't shoot them and then 20 minutes later come back and take something. That's not an armed robbery.
Right.
So I want to make.
That's a fair point. And the Vergara was a weird set of facts where this guy said, "Hey, could I borrow your phone?" with the intent, I'm going to kill you a little bit later. And somehow that was an armed robbery. That's not this. But it went on to endorse and embrace some cases that had said things to the effect of, it really doesn't matter when the intent to take the victim's property arose. And it's in these scenarios of, you know, someone is shot and then the property is taken. Someone is killed and they die instantaneously, then their property is taken. The state doesn't need to prove that the intent to commit the armed robbery existed when the shooting occurred. But to your point, Ms. Feely, they need to all be in the same situation. So I guess you want the ability to argue, no, wait a minute, if there was a shooting, whether it was voluntary manslaughter or not, that had closed, chapter over, and Mr. Dill had gone away, and then he came back and he picked this thing up. That they're two discrete things, and so you can't build this bridge of intent. Okay.
I don't love the Vergara language, but it is authorized to find that if the theft was completed during a discrete incident, but after force was employed, then that's okay. But I don't really know what a discrete incident.
Right.
Clear language for the jury.
What about something like that? I don't like the word discrete either. That's less accessible.
That works.
Okay. Ms. Willingham, we're all doing this on the fly. How would you modify that? I think it is also a correct statement of law that if the facts were Mr. Dill shot Mr. Stafford and got in that white car, then switched to the black car, then got in the white car, and then walked over like, hey, his gun is here, I'm going to take that gun. That's not going to be armed robbery. Too much time has passed for there to be that intent connection. It might be a theft. It might be theft of lost or mislaid property, but it wouldn't be an armed robbery. Now, Mr. Stafford was alive when this happened, so it's a robbery or it's an armed robbery. It's not going to be a theft. Put it, this sufficiently separated by time. I think using the word unrelated actually isn't real helpful to this defense because there's nothing unrelated. I mean, this was all one situation. Okay. All right, so I changed it a little bit, Ms. Feely. I took out the word unrelated because there's really nothing unrelated. This all was one incident. This works?
This works.
Okay. Robbery is the standard charge. That's the pattern. And those were the only changes I made. Anything else from the state about the jury charge? You can, if I'm not going to charge the jury today, you can read over it tonight and flag something. But what you've got now with that one amendation to add the sentence along the lines of what Ms. Feely asked for, you've got the final version. I'll give you a hard copy tomorrow morning anyway, but any issues? Ms. Feely?
No.
Okay. Are you ready, Ms. Willingham, for the jury?
Yes.
Excellent. Ms. Feely? Let's bring them in. I know they're ready.
All right, are you ready? All rise for the jury.
Thanks.
I just heard the calendar.
Thank you, Deputy. Welcome back, ladies and gentlemen. You all can be seated. So we've reached the point where the lawyers are going to give their closing arguments. I've already told you how the state's going to go first and last. I just want to remind you that nothing the lawyers say is evidence. This is their attempt to persuade you that what you've heard means X or Y or Z, and you should feel free to be persuaded if you're convinced that that's in fact what the evidence said. The lawyers may talk some about the law, they're free to do that, but the law that you must use ultimately will come from me either late this afternoon or first thing tomorrow morning. With that, Ms. Willingham.
Course of these 2 days, you all have heard lots of testimony. And the thing I want you to remember the most is that the defendant intentionally killed Jonathan Stafford on November 26, 2021. When everybody else was probably enjoying their family, packing up to-go plates, getting ready to go home, maybe get ready for Black Friday shopping. He was murdering Jonathan Stafford after he had harassed Tatiana Willis Riley repeatedly for months. And on that particular day, for hours, he messaged her, harassed her, so much so that Jonathan felt the need to answer the phone and tell him to stop. He continued to call over and over again. You all will have a duty. You all, as I discussed, over this time, over these few days, you all have had the opportunity to hear, see, you walk through the messages, and it was a total of 45 calls that that the defendant made to Ms. Willis Riley via her social media. It was multiple messages. We saw video footage. He got to her home at 7:30 that evening. And he was there. She was in Alabama. She wasn't even anywhere near her house. You all have a duty. You have a duty to follow the law. You have to remain a fair and impartial judge. Honestly seeking the truth. That's what we're looking for. We are looking for the truth. And it's not hard to find. We saw it. We saw it on video. We saw him shoot him. We saw him walk behind Jonathan. We saw him walk around that car, hide behind that car, walk up on him and put a gun to the back of his head. We all watched it. We heard how many times that gun fired. You're not to see doubt. It's not a whole lot of doubt here. We saw it. Also, you are bound by the instructions of law that are given to you by the judge. I'm gonna go over a little bit, but the judge has already given you the law, and that's the law you're gonna follow when you all begin deliberating after we complete our whole part. Which gets me to your duty to deliberate. Every juror has a duty to deliberate. Each of you all have to go in there and together come up with a guilty verdict. If anyone refuses, you have to bring that to the judge's attention. Because we want to make sure that each of you are doing your job and deliberating. Ladies and gentlemen, you heard statements, you heard expert testimony, you heard the testimony of Tatiana, the victim of the armed robbery in this case. You saw photos, you saw documents. You get to use your common sense and you get to review all of those items. You heard testimony from other witnesses, such as the law enforcement officers, who all talked about the video footage they found, or the photos they took, the physical evidence they collected. And we've gone through the elements of the crime. We'll go through those again. You don't get to use passion in making your decision. Not public opinion. This is you all deliberating based on the evidence you receive. If you're unhappy with the police from anything they've done, you can't consider that. This is not about public feelings. You can't have sympathy for the defendant, which we saw it all on camera. We saw the video. You can't be prejudiced to either side. And you cannot disagree with the law. The law is what you guys have been given, and that's what you have to go by. If you all have questions, you'll have an opportunity to ask those questions. And this is not about penalty and punishment. That is not for you all to consider. You all are only to consider the evidence that was presented and deliberate to come up with a verdict in this case. The burden of proof. The burden of proof rests with the state. We have to prove every essential element of the crimes that are on this indictment beyond a reasonable doubt. That's on us. It never shifts to the defendant. It's on us to get up here. It was on myself and APA Besa to get up here and make sure that we prove this case. The defendant has a presumption of innocence. There is a legal presumption until the state proves guilt beyond a reasonable doubt. This doesn't mean the defendant is actually innocent. Again, ladies and gentlemen, we saw it on camera. We saw the video. We saw the still shots. We saw how long he sat there. We saw him move that black car, that white car. In fact, we saw him move it so much that I had to stop showing you. But there are 4 hours worth of video that show you just how long he sat there. Reasonable doubt means exactly what it says. reasonable. Based upon your common sense and reason. It's not vague, it's not arbitrary doubt. It's not doubt for which reason, it's doubt for which reason can be given. You are not required to prove beyond all doubt. Math doesn't have to be a mathematical certainty. Just reasonable doubt. You see this picture up here? There are some puzzle pieces missing, sure. But a reasonable person can look at that picture and can determine that that's a dollar bill. We don't need all the pieces to know that that is a dollar bill. We see the $1 at the bottom. We see Washington. We know that's a dollar bill. Maybe not the amount of money we want, but it's a dollar bill. Direct and circumstantial evidence. Direct evidence is evidence that points immediately to the question at issue here, which is whether Carlos Dill, the defendant, killed Jonathan Stafford. And we have lots of direct evidence that shows that. We have photographs, we have videos, we have watched videos over and over again. And I know you keep hearing me talking about these videos, and I'm gonna keep talking about them because we watched them, we saw it, we were able to hear what happened. We saw how Carlos Dill approached Jonathan Stafford, an innocent bystander just trying to help his friend get home safe, from behind and point a gun at his head before repeatedly shooting him over and over again. We heard testimony from witnesses. We heard what they saw. Tatiana told you she was out there that night. She told you that when they got there, she didn't see Carlos. She didn't know he was there. She told you that what she did see was she turned around and she saw the defendant. She saw the defendant continue to shoot over and over again. She told you that she heard Carlos's voice before she turned around. That's how she knew it was him back there. When she turned around, it only confirmed it was him because she looked at him. She saw him. She pointed him out in multiple videos, showing you where he moved his car. She told you that. It was all on camera. We don't have to speculate here. It was all on camera. We also had today a video from the apartment complex. You all got to see that. That's the video I referred to when I said there's 4 hours worth of it. We didn't play it all, but it's all there. You can line that video up, those timestamps, and you will see how long he lied and waiting on Tatiana to get home. He got to her home before she ever even left Alabama. He was at her home. All those messages you saw, all those missed calls, he was already at her house. He was sitting out there waiting. Circumstantial evidence. Using direct evidence to infer other facts, reasonable and justified in light of your life experiences. This case isn't really about circumstantial evidence because we have a whole lot of direct evidence. Because again, we have the video footage. We watched it happen. So this isn't a case really about circumstantial evidence. But if we want to consider some things, their shell casings recovered on the scene. We heard that the defendant was shot. The defendant's mother got up here and told you that he was shot. Tatiana told you the defendant was shot. So we know he was shot. But a reasonable conclusion is that during the tussle, because remember, the defendant approached Jonathan from behind. And when he approached him from behind, he pointed a gun to his head. And at that point, they tussled. We saw that. Tatiana told you that Jonathan did. He had her gun in his pocket. She took the gun out. She wanted to make sure the gun was taken out of the car because she has children. She didn't want her children to see her take the gun out earlier. So she had Jonathan bring it in. he stuck it in his pocket. We know that. And in the midst of that tussle, somewhere, the defendant shot. But guess what? He kept shooting over and over again. The defendant did. We saw that. So a reasonable person can conclude that it's very possible that those shell casings, they all belong to the defendant. All of them. Except for maybe one, if we want to believe that. But we can also believe that during that tussle, guess who shot the defendant? He shot himself because he was tussling. They were all wrapped up, all jumbled up together. It is very possible that he did that to himself. But again, if you want to believe that he didn't shoot himself, what we do know is the defendant initially attacked John. And a reasonable conclusion is that those shell casings are from his gun, from the defendant's gun. And Tatiana told you that the defendant had a 9mm. And the crime scene tech told you those are 9mm shell casings. So again, those shell casings, 9 out of 10, are from the defendant. Credibility of a witness. You all determine the credibility of the witness. You all make the decision as to whether the people that sat on that stand were credible to you. And to do that, you consider the manner in which they testify, their interest or lack thereof in testifying. We didn't have anybody up there that was uninterested, not at all. Everyone who invested their time in this case was interested in making sure that they told you what happened in this case. You consider the means and opportunity for the witnesses knowing the facts. Tatiana was there, so we know she knows the facts. She was literally out there that night. She was the person that he repeatedly texted and called, so much so that she told you she had already had to block him from her phone. So then he started reaching out to her on social media and would not stop. You consider the nature of the facts that they've discussed, the probability or the improbability. Again, ladies and gentlemen, we saw it on video. It was on video. What Tatiana said was corroborated by video evidence. We saw it. We all saw it. The testimony of a single witness. Here, most of the witnesses that testified didn't speak to what happened that night specifically. They came in, they picked up video evidence, they picked up physical evidence that was out on the scene, but you did hear from Tatiana, and she, all by herself, is sufficient to establish a fact. But again, you did get to hear from other witnesses. So she wasn't the sole witness in this case. But if she was, that would be enough. Generally, there's no legal requirement that we have cooperation. But again, we do, because we have video footage that was collected by officers. We have physical evidence in the shell casings that were collected. So Tatiana's testimony was corroborated. Expert witness. You all heard from Dr. Cameron. And the law permits an expert to give their opinions based on their training and experience. She talked to you about how long she's been doing her job, and she talked to you about all of her training. She told you that this is actually her specialty, forensic pathology. And when scientific, technical, or other specialized knowledge might be helpful, a person who has special training or experience in that field is allowed to state their opinion about the matter. And that's exactly what she did. And what she told you is that the victim in this case, Jonathan Stafford, died of multiple gunshot wounds to the torso. And his manner of death was homicide. And that was in the report that was provided by Dr. Henry. And she reviewed it because that is part of her job. Identity, ladies and gentlemen. the state has to prove the defendant's identity beyond a reasonable doubt. Tatiana, she knew the defendant, so she knew his voice, she knew what he looked like. There was no question to her as to whether that was the defendant. And she pointed him out in multiple videos, both during the crime as well as videos that she was able to review and see him at her apartment complex before she ever got home. The defendant arrived at the hospital. His mother took the stand. She told you that was him. And then Detective Sendling got on the stand and he explained to you that he knew the person that he saw in those videos was the defendant because of the defendant's shoes. He said that the shoes in that video were the same shoes the defendant had in the video at the hospital. So you have the video of the actual shooting. Detective Sendling reviews it. He sees these gray and white shoes. Then you have the video of the defendant arriving to the hospital with his mother, and she has identified that that is him in that video. He has on those same gray and white shoes. That's how Detective Sendling knew who it was. But again, ladies and gentlemen, Tatiana knew the defendant. She knew who he was. She met him, and they first met in August is the first time that she laid eyes on him. And from August to November, she communicated with him. He showed up to her house, often unwanted. So she knew exactly who he was. Ladies and gentlemen, you are not to use sympathy. Your verdict should be a true verdict based on your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. You can't show favor to the defendant. You can't show favor to Tatiana. You can't show favor to anyone in this case. You are solely to consider the facts objectively without favor, affection, or sympathy to either party. Intent. Intent does not mean that he intended the results. Ladies and gentlemen, he didn't have to intend to kill John. What he had to intend to do was point that gun. And when he fired it, guess what? We all know what can happen from that. We all know that if you shoot someone, it is very possible for them to die. That is a direct result of shooting someone with a deadly weapon. Intent may be shown in many ways. It can be inferred from the proven circumstances or by acts and conduct. Or it may be inferred from the natural and necessary consequence of the act. What's a natural and necessary consequence of shooting a firearm? Death. Death is a natural consequence. And guess what? Jonathan died from the defendant's actions. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intent to commit the act is prohibited by statute. The defendant is not allowed to shoot someone. We don't allow that in society. That's not legal. And he did. And the result of it was Jonathan's life. Criminal intent may be inferred from conduct before, during, and after the commission of the crime. Ladies and gentlemen, we got a lot of before, we got a lot of after, we got a lot of done. Because guess what? Before, he sat there for 4 hours. 4 hours he sat outside of this apartment. He moved his vehicle from one spot to another, trying to wait on Tatiana to arrive home. So he intended to sit out there. So we have plenty before. During, ladies and gentlemen, we watched during this where the defendant shot Jonathan, backed away, shot him some more from a different angle, walked around the car, shot him some more from a different angle. He kept shooting repeatedly. So a lot happened during. So we know his intent during was to kill Jonathan. After, ladies and gentlemen, the defendant then just walks right on past, just walks past Jonathan as he's down on the ground. Because remember, he also shot him while he was down on the ground. Jonathan was already gone. Well, he was already unable to defend himself at that point. And the defendant continued to shoot him and then proceeded to just walk past him. We saw in that same video where the defendant eventually came back, drove up in that car, that white car that Tatiana identified her seeing him get into, and then just pulled back off. He intended to leave Jonathan there to die. What this is not. This is not voluntary manslaughter. Defense will get up here and the judge is gonna charge you for voluntary manslaughter. That is causing the death of another person under circumstances that would otherwise be murder. This is not voluntary manslaughter. This is murder. And acted on only because of a sudden violent and irresistible passion that resulted from serious provocation. What's the provocation here? Ladies and gentlemen, they were text messages. They were text messages that happened hours ago. What did Jonathan do? Jonathan didn't even know anything. You have not heard anything that Jonathan knew to do. So what did he do? How did he provoke him? It's sufficient to, serious provocation, which was sufficient to excite such a passion in a reasonable person. They're text messages. Text messages that happened at 6:30. And Jonathan was killed at 12:30 a.m. Text messages are not enough. There's no serious provocation for David. He waited for hours. Tatiana and Jonathan didn't even know that the defendant was there. He was there in a vehicle that Tatiana said she didn't necessarily know him to drive. She saw him that night get into it. And that's how she knew it was him. When she watched him after he shot Jonathan, she watched him walk over to that white car, get into it, and drive off. But she didn't know that white car had been there for hours because she didn't know to look for it. She had never seen it before. The defendant ambushed Jonathan from behind. We watched him hide behind one car. We watched him slowly walk up, hide behind the car, kind of crouch down. Then he walked around that car, ducking to make sure no one saw him. Crouched down again, then walked from behind it, walked up slowly, went through the cars and walked right up to Jonathan and put a gun to the back of his car. This is not voluntary manslaughter. Voluntary manslaughter, defendant had a cooling off. He had an opportunity to cool down. And if he was really upset from the text messages, again, remember, Tatiana was in Alabama at 6:30. So he had plenty of time to cool down before Tatiana ever arrived home. He sat and waited for her for 4 hours at least. We have video footage that shows he was there for at least 4 hours. And again, ladies and gentlemen, I didn't get to play all 4 hours of it, but it's there. He waited for her. It was 12:36 a.m. when he intentionally approached Jonathan from behind in an ambush and killed him. Ladies and gentlemen, this is not robbery. Robbery is the intent to commit a theft by taking the property of another from the person or immediate presence of another by the use of force, by the use of intimidation, by the use of threat or coercion, or by placing such person in fear of immediate serious bodily injury to himself or another, or by sudden snatching. That's not this case. It's not robbery in this case because the force used here was a firearm. It was a deadly weapon. The intimidation here was shooting Jonathan multiple times, repeatedly. You heard Jonathan was shot 6 times. This is not robbery. This is armed robbery. Ladies and gentlemen, the charges in this indictment, count 1 is murder. Count 2 is felony murder. Count 3, felony murder again. Count 4, felony murder. Count 5, felony murder. Count 6, aggravated assault with a deadly weapon. That deadly weapon, ladies and gentlemen, we've already talked about, is that firearm. Aggravated battery. Ladies and gentlemen, Dr. Sullivan told you that, and even before she told you, when we watched that video, we saw Jonathan's leg turn. When he hit that ground, his leg turned. But then Dr. Sullivan got on the stand and she told you that bullet wound could lead to him being unable to walk. But ladies and gentlemen, we won't know. You know why? Because Jonathan's not. He's gone. But the defendant killed him. Count 8 is armed robbery. Count 9, possession of a firearm during the commission of felony. Ladies and gentlemen, the defendant was committing a felony. Murder is a felony. Aggravated assault is a felony. He had a firearm at the time to commit all those crimes. Possession of a firearm by a convicted felon is stipulated, and there are 2 counts of that. Possession of firearm by a convicted felon as to count 11, we stipulated that there is a qualifying felony in which that charge would apply. Count 1, when a person unlawfully and with malice aforethought causes the death of a human being. Ladies and gentlemen, we watched the video. We saw the defendant shoot Jonathan repeatedly. Malice may be expressed, deliberate, intentional killing. Implied. So malice can be expressed or implied. Implied, no considerable provocation and all the circumstances show an abandoned and malignant heart. Ladies and gentlemen, he kept shooting. Where was his heart? He kept shooting over and over. Where was his heart when he moved to this side to shoot? Where was his heart when he moved to the other side of the car to keep shooting? Where was his heart when he shot Jonathan while he was already down on the ground? We had already seen Jonathan's leg fly up and over his head, and he still kept shooting. This is an abandoned and malignant heart. Legal malice is not necessarily ill will or hatred, but it is unlawful intention to kill. He didn't have to hate Jonathan. He didn't know him, so he didn't have to hate him. But what he did do was unlawfully kill Jonathan, and he intentionally did that. We know it was intentional because he walked up behind him with a gun and pointed it at the back of his head, and then subsequently kept shooting over and over again. If a killing is done with malice, no matter how short a time the malicious intent may have existed, such killing constitutes murder. In this case, we know he sat out there and waited for 4 hours. So he was waiting on somebody to get there. And when Jonathan got there, he then walked behind him. He intentionally stayed low. He intentionally made sure nobody could see him. He intentionally walked behind him and put a gun to the back of his head and kept shooting over and over again. Premeditation. Well, premeditation is not required. We don't have to prove that. No particular length of time is required for malice to be generated in the mind of a person. It may be formed in a moment, and instantly a mortal wound may be inflicted. Ladies and gentlemen, he sat for 4 hours. 4 hours. He was prepared. He walked up to them. We see him walk around that car. We see him inch up behind him. He has the gun out. He points it at the back of his head. This was premeditation. Ladies and gentlemen, motive. Again, we don't have to prove motive, but here we have it. Evidence of motive, if any is admitted, is to show the state of the defendant's mind at the time of the crime. Ladies and gentlemen, we saw in the messages that the defendant was upset that Jonathan answered that phone. He was very upset. He said that. He said he felt disrespected. He was mad that Tatiana wouldn't communicate with him anymore. He was mad that Tatiana didn't want to be with him. He was upset that Tatiana spent Thanksgiving with Jonathan. He was jealous that she was spending Thanksgiving with Jonathan and his family. He wanted to know, why wasn't she spending it with him? So there's motive. Proof of malice. He intentionally snuck up from behind him. He intentionally shot Jonathan. It wasn't enough for him to shoot Jonathan once. He had to keep going. He kept shooting. He acted with an abandoned and relieved heart. His heart is somewhere on the ground, because all he was worried about was shooting Jonathan over and over again. Even as Tatiana tried to tell him to stop, he kept shooting over and over again. That is an abandonment of the heart. He then walks towards Jonathan. While Tatiana is telling him, please stop, he walks towards him again, and he keeps shooting. He shoots 3 more times, I believe, but you'll hear that, you'll watch that video. You'll hear those gunshots. You'll hear them. You'll hear how many times he fired that gun after Jonathan was on the ground, after Tatiana begged him to stop. He kept shooting. He then walks past Jonathan, and ladies and gentlemen, you see him lean down and he intentionally picks up that firearm. He does that intentionally. He again acts with an abandoned and relieved heart. When he picked up that gun, he saw Jonathan was down there. He could have called 911. He could have done something, but he left. He just left. He left Jonathan right there to die. He could have even done something when he drove back, but he didn't. He left. Proof of premeditation. Ladies and gentlemen, we've already talked about the 4 hours of video footage that you saw. He arrived at Tatiana's apartment at 7:37 p.m. in that Buick. We see him back in that Buick. We don't know what time he arrived and parked in Nissan, but what we do know is he was already there and he was harassing her as she tried to enjoy her Thanksgiving. So he was already at Tatiana's apartment. He got there in that view. He then pulled that Nissan around at some point, and he sat there for hours and hours and hours. And when he sat there, he was texting her, harassing her, waiting for her to get home, expecting her to let him in. Ladies and gentlemen, she was in Alabama. She told you at that time she was still in Alabama. He hid behind those cars as they got out of their vehicle. He saw them. They didn't see him. But he made sure he knew where they were. And he inched on around, keeping his distance, hiding, until he walked up on them from behind and he shot John. Felony murder, counts 2 through 5. A person is guilty of felony murder when a homicide is committed during the commission of a felony. Ladies and gentlemen, Dr. Sullivan told you that this was a homicide. She told you that. There must be a connection between the felony and the homicide. Ladies and gentlemen, there is no proof of malice required here. However, we've already talked about there was both express malice and implied malice. There's no intent. There does not have to be intent to cause the death. What we do know is there was intent for the defendant to shoot John. So there was intent for that aggravated assault. There was intent for the defendant to pick up that gun after shooting the defendant. After shooting Jonathan. And probably after shooting himself. But there was intent. If the death occurred while the defendant was engaged in the performance of any felony act, it is felony murder. Defendant involved in a felony, someone other than the defendant died. Well, the defendant's here, so we know he didn't die. You know who's not here? Jonathan Stafford. And he's not here because while he was committing a felony, he killed him. During the commission of an aggravated assault, that's count 2. That's felony murder. The basis of count 2 felony murder is the aggravated assault, which is count 6 of the indictment. He caused the death of Jonathan Stafford. What is an aggravated assault, ladies and gentlemen? Aggravated assault with a deadly weapon. A person is guilty of aggravated assault when they assault another person with a deadly weapon. Well, we know he assaulted another person because we know he shot Jonathan. We know that he intended to cause a violent injury because a gun can only cause a violent injury. He pointed a gun in Jonathan's direction, then he subsequently shot Jonathan repeatedly. He shot him while Jonathan was still standing. Jonathan fell to the ground. He shot Jonathan some more. Jonathan tried to crawl away. He shot Jonathan some more with a deadly weapon. Ladies and gentlemen, how do we know he had a deadly weapon? We saw it. It was in the ring camera video. We saw it. We saw him shoot him with a gun. We saw him walk up behind Jonathan and point a gun at the back of his head, and then we saw him turn around and keep shooting over and over again. We know he kept shooting because there were shell cases. There's surveillance footage. Again, we saw the ring camera video. We saw the video from the apartment complex. And ladies and gentlemen, Tatiana told us. She got up here and she told us exactly what she saw happen that night. And Jonathan is not here because he's now dead because of multiple gunshot wounds that he sustained from the defendant. Count 3 felony murder. That is based on the commission of the armed robbery. Ladies and gentlemen, armed robbery in this instance might not look like your typical armed robbery. However, if a deadly weapon was used, if there was an aggravated assault, if there, in this case, the defendant used a gun to assault Jonathan with that gun, he shot him. And it doesn't matter that his intent to take the other firearm occurred after he shot Jonathan. What matters is that Jonathan is deceased. What matters is that he used that firearm to shoot Jonathan and subsequently took the other one. That's what matters. And it caused Jonathan's death. A person is guilty of armed robbery with the intent to commit a theft, takes the property of another from the person and immediate presence of another by use of a specific weapon. We know he took the firearm. We saw him do it. We saw him as Jonathan's laid out there. He reaches down right next to Jonathan and picks up that firearm and walks off. That gun belonged to Tatiana. So we know that he intended to commit that theft by taking Tatiana's gun. We know he did it in the immediate presence of Jonathan. And we know that he used the firearm because he killed Jonathan with that firearm. And we saw him shoot him over and over again. Count 4, felony murder, and it's based on count 10, which is possession of a firearm by a convicted felon. Ladies and gentlemen, I've already told you, we've stipulated to that. And in that instance, ladies and gentlemen, he didn't cause the death of Jonathan Stafford. He was a convicted felon that caused the death while being in possession of a firearm. We know he had a firearm because there's surveillance footage. We saw it over and over. And we're gonna see it again before the day is over. Jonathan was shot. We know he was shot. We saw it. We heard Dr. Sullivan tell us that Jonathan was shot 6 times. Tatiana told us she saw the defendant with a firearm. We know that he's a convicted felon. There's a stipulation, he's a convicted felon under 15 SC 139-324. Felony murder count 5 is also based on possession of a firearm by a convicted felon. Again, we know he had a gun. He shot Jonathan. We saw him shoot Jonathan. Tatiana told us he had a gun. She saw him shoot Jonathan. And there's a stipulation that he is a convicted felon for qualifying felon under 14 SC 128673. Aggravated battery, count 7. A person is guilty of aggravated battery when malicious intent causes bodily harm to another by rendering a member of his or her body useless. Well, ladies and gentlemen, malice is intent, and we've already talked about that. We've already talked about how we watched him shoot Jonathan over and over again. He intentionally shot him multiple times. Ladies and gentlemen, the surveillance footage shows us when Jonathan's leg splits. We see it. But even if we didn't see it, Dr. Sullivan told us that from her exam, from Dr. Henniger's exam and her review, that he was shot in the finger, and therefore it would be hard to walk. But we know that he can't walk because he's not here. Jonathan is dead. Possession of a firearm during the commission of a felony. Count 9. A person is guilty of a possession of a firearm during the commission of a felony if they had within arm's reach a firearm during the commission of a felony. Ladies and gentlemen, felony murder, armed robbery, aggravated assault, aggravated battery, we've talked about it. They are all felonies. And we've talked about all of those charges. So ladies and gentlemen, I'm gonna get ready to sit down and I'll be back up here later. But what I want you to make sure you do at the end of all of this is find the defendant guilty of all charges for the murder of Jonathan Stafford.
Thank you, Ms. Willingham. Ladies and gentlemen, why don't you stand and stretch a little bit while Ms. Feely gets up? We are going to hear the defense summation right now. Try to make that note, but if you need to stretch a little bit, I'll do the same. Are you good if we keep going or do you need a break? Okay. All right, Ms. Feely, I noticed all the jurors are seated, so they're ready for you.
Again, the real story. You heard about 1 million times about the video. And that is because the state is desperate for you to not consider anything else. Most specifically, not to consider cold, callous, calculated behavior of Tatiana. This case isn't about Carlos Dill. And unfortunately, it's not really about Mr. Stafford. This case hinges on Tatiana. It was a setup. And hopefully we saw through that right now. Started on Thanksgiving. You heard that Tatiana and Carlos were dating. She had his number. She had been to his mother's house. To Carlos, this was his girlfriend. But he was upset that they weren't spending Thanksgiving together. So Tatiana posts on Instagram with another man. Not this is my friend. This is just a caption. She loved that Carlos saw that. She loved that it upset him. She loved the drama she was creating. She continues to engage with him, texting back and forth. Not ever answering his call because he wants to talk. Have this serious conversation. Then, when Carlos is trying to talk to who he considers his girlfriend, Tatiana has Jonathan. The state speculated on what he might have said, but we don't know. But it was a calculated, cold that she knew would upset Carlos. She put Jonathan. I'm sorry. She put Jonathan in that position in the crosshairs. Now, there's no question that I could have asked that I think we would have gotten an answer about Tatiana and Jonathan's relationship. But you can use your common sense and reason based on what you know of him spending his Thanksgiving with her. He drove from Birmingham to her aunt's house and then to her apartment. She takes her children in, and I think the reason she gave about why she didn't get the gun out was because it was raining. But they take the children inside, leave the gun out. They came out to give Jonathan the key fob to turn off, but push to start. Doesn't make any sense. But it's a cover for the real reason, which was she wanted him to get her gun, which he does. She wanted to be seen walking to her apartment with him. And that is exactly what happened. And I don't know that she cared which way he counted. Certainly her actions afterwards suggested she didn't. So this is my only opportunity to address you as you heard. The state gets to go last. So I'm going to talk with you some about the law. The first thing I wanted to address was the state's dollar bill example. All right, first of all, this is a murder trial. This is Carlos Dill's life. This is not about a puzzle. But also with that slide, sure, you can tell that it's a dollar bill, but you can't tell if it's counterfeit. You can't tell what's being hidden by the pieces that are missing. That's the whole of the state's case. They want you to focus on what they want you to focus on. The burden of proof is on the state. And this is really, really important, and I hope that I can get you to understand how high this burden is. Because it's not maybe Carlos wasn't provoked, not probably he wasn't provoked, not most likely he wasn't provoked. This is all the way to beyond a reasonable doubt. And I heard the state say to not look for doubt. That's coded language for don't look for holes in our case. That's absolutely your job as a juror. To hold the state to proving this case so that you do not have a doubt that you can give a reason for, which we will talk about more. And as the court told you, if you do have questions about what happened, if you do find that there is lack of evidence, which we'll talk about, look no further than the state of Georgia. This reasonable doubt standard applies to every element of every count in the indictment. And it also, because you're going to be charged on the lesser of voluntary manslaughter, the state must disprove to you beyond a reasonable doubt that Carlos was provoked and acted out of action. So let's talk about what reasonable doubt isn't. Look at this charge too. But if the facts and circumstances merely place upon Carlos a grave suspicion, which sounds bad, and I don't think the evidence supports that, but even if it did, that is below the state's beyond a reasonable doubt burden. You can be gravely suspicious that Carlos wasn't provoked. I don't think the evidence supports that, but you can, and you still, it would be your duty to acquit him, because that is not beyond a reasonable doubt. Intent is an element of every crime alleged in this indictment and must be proven beyond a reasonable doubt as well. You can't assume doubt, and particularly with the armed robbery count. This was not an armed robbery. It just wasn't. It's overcharged. That charge shouldn't have been included. He picked something up off the ground. It was the firearm. He didn't say, hey, at gunpoint, give me your firearm. This is not an armed robbery. And that charge specifically says by use of a firearm. He didn't use the firearm, he just took it. Didn't have anything to do with that. There's no words exchanged. And the shootout was over by the time that happened. So there's a break, which state's gonna show you that video again, if that's what they want you to narrowly focus on and nothing else. You've already gotten this charge. And what this charge doesn't mean is that you can't feel. You should. You can absolutely feel sympathy for the senseless situation that happened that Jonathan was no longer with us. What the sympathy charge means is that you can't base your verdict. You're not allowed to. You took an oath to do it. You can feel it. You cannot base your verdict on it. So Judge McBurney's going to charge you that your verdict, should you reach one, has to be unanimous. So all of you agree with one way or the other. And that's true. But you don't have to agree about why. You find that there simply is not enough evidence for the counts. So let's talk about reasons to doubt. So let's first talk about talking on his gun and what we know about it. The state told you in opening that she got that gun to defend herself against Carlos. She took that stand and told you she bought it 2 years ago when she moved to this apartment complex. That was simply not true, that she got it. It just fits better story. The awkward setup we've already talked about with the key fob, but really the getting the gun and walking in together. The setup, what it was. The 911 call is a reason to doubt. Tatiana didn't call 911. She's lying. There would be records, and she admitted Fulton County would have a record. Her phone would have a record. There would be a record of it somewhere, even if the system was down, because she said she got a hold of somebody in Fulton County. The state could have seen who was working the phones that day, who would have spoken to her. Her phone records would have shown how she was desperately trying to get through to 911 if that had actually been the case. If the state wants to get that evidence, reach out and touch somebody that works for the state, they can. And if she would lie about that, what else would she lie about? On that video, it does not look like she's on the phone trying to get any help at all for her. She also came in here and claimed things about Carlos to make him look bad that are not supported by the evidence. And she gave the flimsy answer, oh, I thought it would be worse if I got him in trouble. She never filed a police report, no TPOs. She did that to try to convince you that she needed protecting by Donovan. But there is absolutely nothing. No police officer came in here and told you that he took a police report from her or anything. But they need you to believe that, so you won't believe that it was a set of. So the state's new theory is that all of the ballistics came from Carlos's gun and Carlos shot himself. That is a bold claim for a department who did not do ballistics on the weapons. Detective Sendling tried to act like, well, if there's no weapon on the scene, what are we supposed to do? You're supposed to get a search warrant and search things is what you're supposed to do. Interview witnesses, find out where the firearms are. You don't just throw up your hands in a murder investigation and then have the state claim that all the gunshots were from one gun. There's absolutely no evidence of that, because there is no voice. And that's not even supported by what you see the moment that Carlos is shot, because he jumps back. When they separate, and you sure you're gonna see it again. So when the tussle starts, and the state's said about 1 million times that Carlos put the gun to his head. He did not fire. That was intentional. He did not fire. He did not shoot Jonathan in the head. He did not shoot Jonathan in the chest. He gets shot in the stomach, and you see him jump back, and you will see the flashes if you're watching carefully, and the lighting is good enough. Now with ID, the state also has to prove ID beyond a reasonable doubt. And this seems like a minor thing, but the detective comes in here and tells you how important these shoes are. Oh, I saw them in the video, then I saw them at the hospital, same shoes. But he didn't take a picture of the shoes to say, hey, look, it's just his opinion of it, and he's selling it to you like it's facts. It's not. If they were that similar, he would have taken a picture. Grasping at straws. Same thing with the no fingerprints. We don't know who held that magazine that was found on the ground. Same with gunshot residue. He is not a scientist. He should have asked Dr. Sullivan if the gunshot residue could have been tested, because they preserved it like they were supposed to. And it's Detective Sendling as lead detective's job to determine what gets tested. So it's his call. You know, another reason to doubt about missing evidence, because we have to determine whether the extraordinary length of time between what happened and anybody doing anything to help Donovan contributed to it as well. We don't have medical records from Grady. We didn't have the treating physician to come in here and tell you what they tried to do, what they could have tried to do, what was attempted, how long he was there. Because this does not fit. If we had had medical records, they would not have fit this. This is not acceptable. You deserve to hear more about Jonathan's condition and what the delay contributed to. Because that's another reason to doubt this, is the absolutely heartbreaking delay in medical care for Jonathan. You were told by Dr. Sullivan he died of Grady, and that there were signs that medical professionals would, given the opportunity, try to save him. Dr. Sullivan also told you that the gunshot wounds themselves were not immediately fatal injuries. She pointed out for you the 1,400 milliliters of blood in Jonathan's. So the internal bleeding that he was suffering, in addition to the external bleeding. You don't have to be a medical professional to know that that bleeding could have been stopped with prompt medical attention. That bleeding could have been stopped had he been driven to Grady, a trauma center. There are ways that he could have been helped. And we know it because we see Carlos here. Someone cared enough to render Carlos safe. His mother tried to stop the bleeding. Someone cared enough about him to take him to the hospital. And that is unacceptable that that's not the case with Jonathan. Within moments of arriving at Grady, Carlos is there. He gets surgery. Tatiana was cold, callous, and calculated in her response. She came in here and told you she's a certified medical assistant in nursing school. She was told by someone, an unnamed person, we don't know their medical affiliation, if any, not to touch him. But we can see in the video that we were going to see again, that Jonathan was moving, Jonathan was talking. This wasn't a spinal cord injury. He needed help stopping the bleeding, which she could have done. That's not a question. Even at the end of the video the portion of the video that I showed you, the state, Tatiana testified Jonathan was definitely alert and responding to her at that point. Even 6 minutes later, or whatever the timestamp was, of the portion of the video I showed you. But he wasn't 45 minutes later when he helped her. Reasons to doubt Carlos Dill's guilt include the fact that Tatiana did not render aid, did not help him, didn't alert the neighbors, knock on doors, scream for help, comfort him, try to stop the bleeding. The biggest one is she did not drive him to the hospital. That simple thing that saved Carlos, she did for just a heartbreaking amount of time, too long. She never does. And she never calls him anything. She calls her sister. When you watch that video again, look, see if she looks like somebody who's trying to get a Carlos to Jonathan. So what does she do while Jonathan waits there? Tells Carlos, says, I think I've been shot, or I've been shot, and she tells him, well, you better go to the hospital. She told Carlos that while Jonathan was on the ground. She told us she called her sister. We see her go somewhere out of frame for several minutes. We see her come back into frame with the children and put them in the car. She does not look like somebody who's scared of Carlos from there. She saw him leave already. And if you were scared, you certainly wouldn't pull your children out of the car and bring them to the car.
Can you hold on for 1 second? You guys in the front row need to stop gesturing or you need to leave the courtroom, okay? I guess you're technically in the second row, but I'm looking at both of you. No more hand gestures or anything, or go outside. You'll be watching them, Deputy Gordon? Thank you. I'm sorry, Miss Feely.
When you watch the video again, pay attention to her strolling down the sidewalk. Does that seem like care or concern? Or fear? No sense of urgency, no frantically trying to help Jonathan. Tatiana testified yesterday that Jonathan's sister and family aren't friends with her anymore. I would bet not. After she set him up with his violent conversation. At best, she wanted there to be an altercation. Maybe, I don't know what she was wanting, but we do know she lawyered up. She's never been criminally charged. She walked into this courtroom with an attorney. And the state didn't want you to know that because they objected. But Tatiana's priority is Tatiana. That's what we've seen throughout. She knows what she did is horrible. She knows what she did is wrong. She remains never charged as any involvement in this case. So she had to minimize her involvement, lie about her involvement. Because this is the DA's office that was prosecuting her. So reasons to doubt on the murder and felony murder count. This was a non-fatal shooting, if it weren't for Tatiana. Carlos would face aggravated assault charges maybe. Jonathan will be here to testify. The state is asking you to punish Carlos for what happened after the shooting. For Tatiana's cold, callous, calculated move, but you don't have to. You can follow the law. And it's important to understand too that murder is murder is murder. This was not murder. This was voluntary manslaughter, which we're about to talk about. So it's going to be given to you as a lesser included offense of murder, And it's what fits, if anything, if you find Carlos did enough to cause the death himself without the lack of medical care. You have questions in, you know, or you know there's more to it. That is reasonable doubt. So the state has to disprove that he was provoked. That means not that we prove it, they have to disprove it, to non-reasonable doubt. And if you find that he was sufficiently provoked and acting out of passion, you may not return a verdict of murder. You would be authorized to find him guilty of that from voluntary manslaughter. The state can't disprove that he was provoked and that he was acting out of passion. The state cannot prove beyond a reasonable doubt that Tatiana didn't provoke him and wanted. The provoking was built up, but the provoking was having Carlos see her with him. That was the most of the provocation, not the 4 hours later when the state tries to say was the cooling off. Provocation was seeing the two. There was no cooling off when after that. So if you find Carlos guilty of voluntary manslaughter and you believe that he did enough to contribute to the death, then put the murder counts aside, because murder is murder is murder, and that is not what this is. So again, I don't get to talk with you, and as soon as I sit down next to Carlos, I'm gonna think of 100 things I should have said, but I'm gonna keep it thinking for him and as powerful as I can. But don't let the state make you forget what the evidence was and what it wasn't. Because you more to it than the video, like I told you there would be in the video. Do not let the state lower their burden. Do not rubber stamp this. The state's probably gonna tell you not to look for doubt. We know what that means now. It means don't pay attention to the holes in the case. Not proven is not guilty. So if the state hasn't proven to you beyond a reasonable doubt that Carlos wasn't provoked, that equals not guilty. And the state can't do it because Tatiana did it. We'll get this due. They have to prove it should not, the murder count should not be reduced. That's a question now for you, or not for anyone else. We've talked about all the reasons that you should be very unsatisfied with this case. You should feel unsettled about what happened and the decision that you now have to make based on just the evidence that you heard. But if your minds are wavering, unsettled or unsatisfied, that is the doubt of the law. So if you feel that, which you should, you must acquit Carlos. We're asking that you return a verdict that reflects what really happened here and why, and who really is responsible for setting that. We're asking you, if you find that Jonathan's death was caused only by Carlos, that you find him guilty of voluntary manslaughter and everything else, and find him not guilty on the rest. Thank you.
Thank you, Ms. Feely. We're going to take a quick break because someone may need to use the restroom, but we're going to need to use the rest of the time you've got here for the state's rebuttal, the second half of their closing. If you don't want to go in the jury room, you don't need to, but you're welcome to. Let's get you all in the jury room. We're going to keep the break kind of short. It's already 4:10. We may go a little past 5 because we didn't start till 1, but I would like to get in part 2 of the state's closing before we wrap today. So you get point, counterpoint, go home, and then we'll do the charge in the morning. So please don't talk about the case. Take a few minutes, and then I'll have Deputy Gordon see if you're ready to come back in when we're ready. Thank you. All right, you all can be seated. Ms. Willingham, anything we need to talk about before we take a quick break? You'll be ready with the PowerPoint, if you have a PowerPoint, whatever you're going to use. Okay, Ms. Feely, anything?
Yes.
All right, I'll be out in a sec.
What'd you say?
And our doors open.
Mhm.
I'm not going to be right now.
No. Do you need backup?
Oh, yeah. How long do you say this break was?
He didn't say. Yes.
Hey.
I didn't think he was coming back.
Have as many as you like.
Cool, yeah.
States can be that this would be worse than their first mother could be repeated
I think so, man. I think I was paying attention.
But they are not though.
Can I please see one lawyer from each side? Right away, but super short.
Yes, it will be.
It's worked the same way the whole
I
trial.
know.
You think it's an investigator, but it's not gonna be like you'll never be court that fuck around with that. You told the judge so that person being told not to.
I am, but she's needing to take care of what we talked to. Did she talk to you or not? You see, you're in the dark. Sorry about that. She'll get you up to speed. I'll give her a few, well, if she needed to, I'll give her a few more seconds. I'm printing out the proposed verdict form so you all can look at that. All right, let me let the printer stop. It's a little noisy. Okay, let's go back on the record, please. We have Mr. Dill in court with his lawyers, as well as the prosecutors. Ms. Mahone, your concerns were shared with me, and I've asked the district attorney's office to address that. It's not something I picked up on, but that doesn't mean your concern isn't very real. It's not what's supposed to be happening here. I was a little distracted by some of the things that folks who I think are associated with Mr. Stafford were doing. But I've talked with the district attorney's office, obviously shared your concern with counsel on both sides. So we should be okay. If you've got a concern, just let one of the deputies know, okay?
Thank you.
All right. Ms. Willingham, anything we need to talk about before the jury comes in?
No, Your Honor.
Okay, Ms. Feely?
No, yeah.
All right, let's bring the jurors in, please. Plenty, more than an hour. But she told us hour 15-ish for the total, so. An hour and 13. If you're gonna set a timer, it better not go off. In federal court, they had an actual timer.
Roger is present.
Thank you, Deputy Gordon. You all can be seated. So ladies and gentlemen, last segment for today will be the state's rebuttal, part 2 of their closing. And then we'll probably call it a day, and we'll talk a little bit about when you want to start tomorrow with what will be the jury charge. And then evidence will go back with you and you'll begin your deliberations. Ms. Willingham, when you're ready.
Ladies and gentlemen, let me tell you a little story. Sanding basket. So, an officer works for Border Patrol, and every day for 30 days, he sees this young man riding this red bike with a basket that's sanded. Every day for 30 days, he goes through the sand in that basket and inspects it to figure out what's in there. He finds nothing. He lets the boy through. On day 31, the boy comes back through. He's walking. He doesn't have the bike, so there's no basket. Inspector asks him, what have you been coming through in that basket? He says, you were paying attention to the sand in the basket. There was nothing in it. It was really, I was smuggling in a new red bike every day. Ladies and gentlemen, I tell you that story because the fish just got up here and you just heard lots of sand. You heard lots of sand in the basket. Setup. Ladies and gentlemen, which one is it? Was it setup? Was he provoked? The burden doesn't rest on defense. But since they brought it up, I want to make sure that I address it. There has been no evidence of a setup. Even if there was evidence of a setup, guess what? The defendant would still be guilty. She put Jonathan in that position. So we're victim blaming. Defendant is responsible for his own actions. Carlos Dill, the defendant, is the one who shot and killed Jonathan. Carlos Dill, the defendant, is responsible for Jonathan's death. Tatiana, she's not on trial. Carlos, he is. He killed Jonathan. Set up, or is it voluntary manslaughter? Was he provoked, or did Tatiana set him up? Which one was it? There are two different theories, ladies and gentlemen. Again, the defendant does not have a burden. But which one is it? You can't have both. It cannot be both. Either he was set up or it was provoked, not both. Defense says that it's not an armed robbery. Well, ladies and gentlemen, you don't need words. I don't have to walk up to you and point a gun. That doesn't have to happen. Jonathan did not have to have a gun pointed at him and Carlos demand a gun. That does, or demand his items. That's not how that works. No words have to be said for it to be an armed robbery. What does have to happen, intent can be formed in the instant he picked up the firearm with his gun in his hand, regardless of when the intent arose. In this case, the intent arose after Carlos already shot him. Jonathan was incapacitated at that time. He's already down on the ground. There is literally nothing he could do. He still had the intent to pick that gun up and take it. And that's what we saw him do in that video. Tatiana didn't call 911. Well, first off, Tatiana told you she called 911. She told you the system was down. If the system was down, there would not be a record of it. But she told you she called 911. Defense talked about IDing the defendant. Well, we have messages. Tatiana had those messages. We went through all those calls from the 25th. Tatiana talked to us about the message that she sent to the defendant's mom. The defendant's mom got up here and said, yes, that's the message. That's what she sent me. I got it. I remember that picture from it. She didn't know it was a Zoom. She didn't know it was of a Ring camera, but she knew she got that picture. The magazine. Well, we know who was shooting. You know why? We watched the video. We saw the defendant shoot Jonathan multiple times. A GSR test for gunpowder residues. Again, we know who was shooting. We watched the defendant do it. We watched him shoot Carlos over and over again. Time of death, that doesn't create a reasonable doubt. What we do know is Jonathan's not here. We do know that Jonathan succumbed to his injuries. We do know that Dr. Sullivan said that he died of multiple gunshot wounds. But for the defendant, Jonathan would still be here. But for him shooting Jonathan, he would still be here today. He wouldn't have needed help. He wouldn't have needed life-saving measures. Defense says Tatiana was strolling down the sidewalk. Well, Tatiana testified. She said she was in shock. Every reasonable person deals and reacts differently. That's her reaction. She was in shock, and that's what she got on the stand and told us. This is not voluntary manslaughter. People cannot just go around killing other people because they're mad over a message. Some more saying, we heard about the ballistics, Tatiana making sure her children were safe, and that she didn't render care. Well, there wasn't a gun because the defendant took both his gun and the gun that Jonathan had, which was Tatiana's, that was in Jonathan's pocket. The defendant took them. We saw it. We saw him pick up Tatiana's gun off the ground. That was in the video footage. Further, we don't need ballistics. We literally saw the defendant shoot Jonathan over and over again. Tatiana's children. Ladies and gentlemen, that video's up there. It shows you Tatiana with her children, taking them to the car, making sure they're okay. A reasonable person would do the same. He had a gun. She didn't know if he was coming back. He had just killed her friend. She watched him kill her friend. She did what any reasonable person would have done, which was make sure her children were safe. And she still called 911. She told us she was on the phone with 911 as she was walking. Or she said it could have been 911 at that point, or possibly his sister, the victim's sister, Jonathan's sister, or her sister, but she was unsure which person she was on the phone with at that point in time, but that she called multiple people trying to make sure that Jonathan got help. The first being 911. She says she didn't move him because bullets traveled. And she mentioned an older neighbor also told her not to touch him. She listened to that advice. She didn't know what else to do. She was in shock. Her goal was to get an ambulance there. And again, she did call 911. She told us 911 was down. Detective Sendling told us system was down. Ladies and gentlemen, this is all sand in the box. Malice. Ladies and gentlemen, the defendant laid in wait. He ambushed Jonathan from behind. He pointed a gun at the back of Jonathan's head And the defendant in this case didn't even know, or Jonathan didn't even know that the defendant was there. Tatiana's gun was in Jonathan's pocket at the time of this incident. He came up from behind her. He pointed that gun at his head and he shot him over and over again. Again, he pointed the gun at the back of his head. Jonathan had no idea he was behind him. He had no idea. Don't pay attention to that saying or you're gonna miss the bite. What you should pay attention to, Tatiana told us January 2021, she exchanged numbers with Carlos. She said that happened via social media. August of 2021, Tatiana and the defendant met in person for the first time. She said in September, she started to notice the defendant's controlling behavior. She noticed he would be driving past her job in his mother's car. October, he begins showing up at her home unannounced and unwanted. Text message, she texts the defendant's mom. We saw that. Tatiana told us that was her message to the defendant's mom. Further, the defendant's mom confirmed that she received that message. She recalls seeing that picture. And underneath that picture, Tatiana said, "Look at your son." Now, defendant's mom said she can't identify her son. She can't identify him in that picture. But Tatiana knew who was standing outside her home that day. November of 2021, defendant starts showing up at Tatiana's home with his 5-year-old daughter, sending her to the door alone, trying to get Tatiana to open the door. Because it's a 5-year-old standing outside her door. She's not gonna leave her standing there. November 25th, Thanksgiving Day, 2021. Defendant repeatedly called Tatiana on social media using Instagram. Called her over and over, 45 times. You'll get those photos of those screenshots. You can go through and count them for yourself. 45 times he called her. Call number 18. It took 18 calls before Jonathan ever answered that phone. 18 times he had called her, and that was in less than an hour. You'll be able to review that on those photos. On November 26th, after Tatiana arrived back from Alabama, spending time with Jonathan's family, spending time with her family for Thanksgiving, like most people would do. The defendant had been lying in wait for them. And when she arrived home, they got out that car and he hid behind another car, hid behind yet another car, and then walked up from behind and maliciously killed Jonathan Sapp. Defense even told you that he pointed the gun at his head. So we know he did. Tatiana's testimony, 6:32 p.m. You'll be able to review those messages. They'll be bigger. At 6:32 p.m. is the first time the defendant called Tatiana on social media. 7:50 p.m. I'm sorry, 6:51 p.m. Jonathan answers a call. So from 6:32 to 6:51, there were 18 missed calls. And on, 17 missed calls. And on call number 18 at 6:51, less than 30 minutes, Jonathan finally answers that phone. And by 7:50, that's the last call. Now there are messages that happen after that, but 7:50 p.m. from 6:32 to 7:50 p.m. there were 45 calls to Tatiana. Only 2 of them, her testimony, only 2 were answered. One that she answered and hung up, one where Jonathan answered, because they wanted the defendant to stop calling. It was Thanksgiving. They were just trying to enjoy Thanksgiving. Here you see that call at 6:32. Here you see at 6:51. That is the call that Jonathan answered. But again, ladies and gentlemen, that was call number 18 within 30 minutes time. 7:50. Jonathan calls Tatiana for the last time, but he keeps messaging her after that. Ladies and gentlemen, Tatiana also testified to you that at 7:50 p.m., she was still in Alabama. And we saw saw video footage. You didn't see the whole 4 hours, but it's available to you. He was already at her home. He was already sitting out there waiting. 7:37 p.m., unbeknownst to Tatiana, Carlos arrives at her home. 9 p.m., Tatiana told us that's when she was driving back from Alabama. She told us at 11 p.m., she arrived at her aunt's house, and Jonathan arrived shortly after. They came back from Alabama in 2 separate cars. By 12 a.m., between 12 and 12:25, she wasn't exactly sure of what time she left her aunt's house, but between 12 and 12:25, she leaves her aunt's house. She arrives to her apartment at 12:27 a.m. Her and Jonathan both, they arrive in separate cars. Tatiana pulls in, Jonathan pulls behind her. He goes to move her car. At 12:30, we then see Jonathan walk to Tatiana's car to move it. Tatiana takes her children inside. By 12:35, she goes back outside because she needed to give him the car. 12:35, we also see the defendant walk up and hide behind the car. We see the defendant then come around, and by 12:36, the defendant was maliciously attacking, ambushing Jonathan from behind. And he shot him 6 times. Ladies and gentlemen, it is on camera. Here we see the defendant near that white car. We see him near that view. You've seen that video footage. We've talked about it. We've compared it to the surveillance footage from the apartment complex. We know that it is 4 hours before Tatiana ever arrives home. Here, Tatiana told us the person that gets out of that car is Jonathan. I'm sorry, it's Carlos, the defendant. And she also tells us that when the defendant gets out of that car, the reason she recognized that car is because she had seen it at her apartment complex before. And guess who she saw there when she saw it? Him, the defendant. Ladies and gentlemen, you also see next to that car where we see the defendant, we see that white car. We know he was in that white car. Tatiana already told us that that's the car she saw him getting after he maliciously ambushed and killed Jonathan. He shot him 6 times, ladies and gentlemen, 6 times. The defendant lied in wait. That's malice murder. Look at him. He walks behind that car, and he's gonna walk behind this other car. Ladies and gentlemen, I recognize there's a little bit of delay in the video, but don't worry, it'll be accessible to you. You all can view it again. But you're gonna see, as you see him go up, he's walking behind Tatiana's car now. We see Tatiana and Jonathan down at the end. And who do we see ambush Jonathan from behind? None other than the defendant. Look at it again. There he is, hiding behind that car. Jonathan and Tatiana, unbeknownst to them, they have no idea he's back there. They don't see him. He's hiding. He's intentionally hiding to make sure he's not seen. They walk unknowingly. Jonathan has no idea what's about to happen. And unfortunately, what happens to Jonathan is he loses his life because of the defendant, Carlos Dill. It is on camera. This was a malicious ambush. He hid behind cars and made sure that he was not seen by Tatiana or Jonathan. He waited until their backs were turned. And then he approached them from behind. And ladies and gentlemen, we don't have the sound playing right now, but again, you'll have access to this. You can watch it, you can hear it, you can hear how many times he shoots at Jonathan. We see Jonathan there, he's already on the ground. He's already on the ground. And the defendant kept shooting over and over. Dr. Karen Sullivan, she talked to you, she told you Jonathan was shot 6 times. She told you that the gunshot in the right upper quadrant abdomen could have contributed to his death. She also told you the gunshot wound that entered his mid-back and went through his right lung and exited through his armpit did contribute to or was the cause of his death. Jonathan died from gunshot wounds of the torso. Both of those gunshot wounds. The manner in death was homicide. Dr. Sullivan told you that the manner of death for Jonathan Stafford was homicide. And that was a homicide at the hands of the defendant, Carlos Dill, not Tatiana, as the defense would have you believe. Ladies and gentlemen, that was Jonathan Stafford. That was him on his wedding day. That's one of the last photos taken next to the picture of his wedding day, because he's no longer here. I ask you, ladies and gentlemen, to follow the law. Put your personal feelings aside. Hold the defendant accountable for his actions on November 26, 2021 at 3440 Boulder Park Drive, Atlanta, Georgia at 12:36 a.m. when he murdered Jonathan Stafford. He intentionally and maliciously killed Jonathan Stafford that night. And we don't tolerate this behavior in our society. I ask, ladies and gentlemen, that as I prepare to go sit down and you prepare to get instructions, not necessarily deliberate today, but I ask that when you begin deliberations, find that the defendant is guilty of all charges in this indictment. Thank you for your time.
Thank you, Ms. Willingham. We're just shy of 5 o'clock. I can't see what's on that screen. You took stuff down? Great. Okay. We're just shy of 5 o'clock. And I think we're going to stop for today. What we'll do tomorrow morning when you get here, all 14 of you get here, is that I'll give you the jury charge that you'll need to receive so that you have the law that you will apply to the facts as you find them to be from all the evidence you've received over the course of the day and a half we've been doing this. That charge doesn't take it's going to feel long because it's a lot of legalese, but 20 minutes, maybe 30 minutes, and then you're going to have the rest of the day to deliberate. And I share that with you because if 9 o'clock is a tricky start time for some of you because of commutes, we can start at a different time. We're basically reached that point where you can collectively decide when we start and when we stop. Because we don't have witnesses coming in. The lawyers will be here whenever we tell them to be here. So if 9 works for everyone, great, but why don't you just sort of look at each other and talk off the record about when you'd like to start tomorrow, and then I'll make it official. All right, hearing no objections. You all should aim to be here at 9. It'll be not like today, it'll be like 2 days ago, that kind of flow. The shuttle runs a little more frequently. There's just different traffic on the streets and highways of Metro Atlanta. We'll wait until all 14 of you are here. Please do call my chambers if you get stuck somewhere and you're running a little bit behind. I'll give you the charge and then you'll begin your deliberations. It's real important that you maintain that seal, that bubble that you've had tonight as well. The evidence is closed. It's never okay to do outside research, but now it would be doubly not okay because there is no more evidence to consider. You've got it all. If it's not enough, it's a problem for the state. If it's enough, you may decide that the defendant is guilty of one or more of the charges, but you've got all the evidence. The lawyers have now very effectively argued their perspective on that evidence. Of course, what really matters is your perspective on the evidence. I'll give you the law that you put down as the grid. You fit the evidence in, guilty, not guilty. And that's what you'll get to do tomorrow. Once you start deliberating, you'll break for lunch when you're ready to, all that kind of stuff. And we'll talk about that tomorrow. But tonight, please stay in that cocoon. Just do anything other than interact with people about the case. Any logistical questions? We received your gift. Thank you. I haven't tried one yet, so I can't tell you thank you for sure, but the thought is what counts. We'll see everyone as close to 9 as you guys can make it. Thanks so much.
All right, sure.
You all can be seated. So juror 45, who will become the pastry pimp, his title, not mine, when he opens his new store, brought in a few cupcakes for my staff. That's what I was interacting with him about. So that's very thoughtful of him. He may feel less congenial when he learns he's an alternate, but we'll see what happens. Ms. Willingham, anything from the state before we break today? You can look at it in the morning. I printed out the verdict form. Both sides will need to be okay with that. It's a little different because there are 2 counts with alternatives to just guilty and not guilty, with the voluntary and with the robbery. So you'll want to look at that. I think you've got the final version of the jury charge. I will have hard copies of the final version that I'll be reading. And I think we've all had trials together, but there will also be up on the screen. I publish it while I read it, so jurors can follow along. They stay a little more plugged in to the jury charge. It would be great if you all, whether you want to stay a few minutes now or get here a little early tomorrow, huddle up about what does not go back with the jury. What jurors don't like, and I join them, is we say, all right, go back, but you can't start till the evidence comes in. And then the lawyers are going through everything and getting in order. And then there's a argument about what shouldn't go back. I've got a pretty good sense about what ought to go back, but I will react in part to what you all have to say about it. So why don't you plan to be here a little before 9 to do that? Okay. All right, Ms. Feely, anything on behalf of Mr. Dill? Okay, thanks everyone. And you've got clothing for Mr. Dill for tomorrow. Great. We'll see everyone a little before 9. Thank you.